With my Lord's kind permission, we are all for one matter. Just to remind my Lords, Friday it was there. It was adjourned to. He said your Lordship will take it up. Your Lordship said Monday will take up this matter.
Which matter?
That service matter, my Lord. Some urgency is there, imminent urgency is there. Otherwise, you would not have probably.
Because they are on Friday at item 10 for Lordship. May not be possible. The judgment has to be delivered.
Can it be taken up tomorrow?
No,
Or today after lunch?
tomorrow is a different bench is there.
Today after lunch?
May not be because all the necessary that once you hear the matter other side.
Can we put a fresh matter? It's a fresh matter. Fresh admission.
Admission can be done, but not
fresh admission. Not hearing. Fresh admission.
Then put it on day after tomorrow. Day after tomorrow.
Only Humble's ready at the top. Otherwise, you cannot hear Lordship.
Why my landed
I thought it's a final decision.
No, it's fresh admission.
Fresh admission.
All right.
Great.
I'm filing a mention for IA regarding interim bail matter.
Give it.
Criminal appeal, fresh admission, and another is the appeal for bail.
Bail.
Pardon, mention there is a fresh admission. This is against the order. They are not noticed as in the Surface Act before taking the possession of our house. This is a housing loan case.
So, madam, possession has been taken.
Yes, madam, 22 only.
Possession notice has been issued.
No.
13-4.
No.
Then why have you come?
We're coming this without giving the notice.
So
taking the
your grievance is that without issuing notice, the position has been taken.
Yes.
So position has been taken.
Position has been taken. You have to go to the DRP. There must be first they must be giving you notice to pay this amount, and opportunity will be given 13-2, then 13-3A, then they pass the order, then the 13-4 comes. So if that stage has come, then you have to give it. That will be the result.
Yes.
Okay.
Maybe you come.
It will come on day after. Yes, sir.
I may pardon to mention, Your Lordship. I mean, BC, Your Lordship, item 25, Your Lordship.
Yeah.
I pray, Your Lordship, we have required some documents. I pray kindly taken back after vacation, Your Lordship.
Yeah. Item 25 of today's board.
Yes, sir. Yes, Your Lordship. Today's board. Yes, Your Lordship.
What document you require? 25 is a condonation of delay application.
Yes, Your Lordship. There is a limitation.
CRLA 1174 of 25.
Yes, Your Lordship.
What document you want? Let it remain.
Your Lordship.
Yes.
Your Lordship, I pray only kindly taken after. Oh, all right. Grateful, Your Lordship.
For interim bail. Give it.
Pardon to mention one CRLA 678 of 125 matter. This case was specific and week commencing 2710 for this.
What purpose?
My lord, this case, my lord, deposition 1 to 28 is available with me, but 29 to 40 is not available. That's why I'm looking for
bail application.
Yes, my lord. Criminal
give the memo. Yeah.
Weekly daily item number 1.
The connected matters. Connect first item and the last item. There are both two appellants.
No. Why he has
independently prepared CRLA the sub item 135.
That JCRLA would go now because this is only one Nakolojana.
Another is why.
Nakolojana and Sanjujana both have convicted. They have independent JCRLA.
Let's see that maybe Nakolojana son of Swanso is this Nakolojana.
Same.
So that is why. So JCRLA would go and since you have filed that would remain. Let's come. JCRLA number 29 of 2025. This JCRLA has been filed by appellant Nakulo Jena, challenging the judgment and order of conviction passed by the learned ad hoc additional sessions judge FTSC 2 bracket ends Jajpur in so and so case. Stop. It appears that the very same appellant has already preferred CRLA number 1352 of 2025, challenging the sanction, impugned judgment and order of conviction, which is a regular appeal. Therefore, this JCRLA is disposed of. Now, Mr. Samal, second of CRLA. What is the delay has been pointed out by the stamp reporter? 205 days.
159 days, my lord.
145 days.
145 days.
And it's a 302 case.
Yes, my lord.
All right. We are condoning the delay, life imprisonment. Look on IA number so and so. This is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 145 days in filing this CRLA. After going through the amendments taken in the interim application, hearing the learned counsel for the respective party, and since the petitioner has been sentenced to life imprisonment, we are inclined to condone the delay in filing the CRLA. Accordingly, delay is condoned. IA is disposed of. Hard admit call for the trial court records, interim applications for bail and stay realization of fine to be considered after receipt of the trial court record. Learned counsel for the appellant shall supply the deposition copies of the witnesses to the learned counsel for the state in the meantime. Yes. So what about the next one? Sanju Jana. Sanju Jana.
Sanjujana is your wife, my lord.
No, don't wait. ଆପଣ ତା ଦେହରେ ଅଛନ୍ତି କି ସଞ୍ଜୁ ଜେନା?
Both are joint citizen. Joint
husband and wife.
Husband and wife.
Same କରିଦେବେ ହେଲା ଯେମିତି ଫାର୍ଷ୍ଟ ଡାକିଲେ ଦେଖିଦେବେ ସଞ୍ଜୁ ଜେନା ପାଇଁ ଇଏ ଫାଇଲ ହେଇଛି ବିଚ ତମେ ଏଟା ଡିସ୍ପୋଜ ଅଫ ଦିଟା yes sure. Next.
Item 2.
In this case, the petition of challenging the learned tribunal's order dated 25/6/2025 filed in OA number 113 of 2022. The letter regarding MSCB Howard Miller. The learned tribunal which decision relied upon that is S. Gopaladu versus Union of India. Just now I want to know that order is challenging in this.
Yes. What orders have been passed in those cases? Similar matter has been filed. We know that. So some orders have been passed. Are you having the copy of that order?
No. Just now I came to
furnish this copy. Look on the learned counsel for the Union of India. You are Mr. Sethi?
No.
Senior panel counsel.
Senior panel.
And senior panel counsel submits that this petition has been filed by the petitioners challenging the order dated so and so in extending second and third MSCP to the opposite party from 11/5/2013 and 11/5/2013 in OA number 113 of 2022 by the Land Center Administrative Tribunal. He further submits that he has come to know that similar matters are sub judice before this court, and will be given some time and produce the order passed in those cases, and the matter may be taken up on some other day. List this matter after entering winter holidays. Yes.
Item 3.
May I begin with you? Before he challenged my lord, order dated 19/8/2025, passed by the OERC, my lord, did not allow the differential amount as GRF has already passed on 22/11/2024, my lord.
No, some council used to appear for this OERC. There is a panel council, and are you aware about his name? Is I don't know. Maharana, right?
Maharana is appearing TP Shurel. Data power.
Also
No,
OERC.
OERC ତାଙ୍କୁ ଟିକେ ପଚାରି ଦିଅନ୍ତୁ। ହଁ
ଆଚ୍ଛା OERC ର ବି ଇଏ ଅଛନ୍ତି।
OERC ପାଇଁ କିଏ ଜଣେ council last week appear महाराणा तो ଅଛନ୍ତି ବୋଧେ ହଁ but OERC ର council ଅଛନ୍ତି ସେ କହିଲେ ଆମେ ଯେ panel council ବୋଲି what we want, you just give a copy, we can take off and TPCODL ne madhya ଅଛି you are making the TPCODL party also like 5, 6 and they are for them also Maharana is to appear. Lalit Maharana, na?
Lalit Maharana, yes, Lalit Maharana.
Give the copy and ascertain from him, he might be knowing that which the council used to appear for OERs. Listen, Mr. Swine, London Council for the petitioner submits that since Mr. Lalit Maharana used to appear for TPCODL for the opposite parties number 5 and 6 in this petition, he may be permitted to serve a copy of the petition on the land council and also ascertain from him regarding the name of the council who is to appear for OERC, and that is the opposite party number 4, and also serve a copy on him. It is this matter after ensuing winter holidays. Yes.
Item 4.
May I please the Lordship? Lordship, item number 4, learned DSG along with Mr. S.S. Kashyap, learned senior panel counsel is appearing in this matter, Your Lordship. My Lords, the senior panel counsel is unwell, for which Your Lordship I pray for some time.
Senior panel counsel, who is not well?
Your Lordship, Mr. S.S. Kashyap.
His name is not there. Mr. Counsel is a Bukaichi, Hannu Bhaskar and P. Burma and P.R. Burma. 3 names are there.
My dad, I am P.R. Burma, Pratibha Rani Burma.
Acha.
So, main counsel is Hannu Bhaskar.
Bhaskar. So what is the question? What's it?
I would call na question.
SS Kashyap you have telling?
Yes, Your Lordship, it has been allotted to Mr. Kashyap also.
Appearing on behalf of the opposite parties, that is what problem has been said.
You are mentioning for Union of India or you are mentioning for
Union of
the
India,
opposite party?
Union of India is fine.
The Union of India ro na coaching ke jo.
Madam, you are appearing for opposite party or petitioner?
Petitioner Union of India.
Union of India.
Then
He's telling about SS Kashyap.
SS Kashyap is a panel council na for Union of India.
Yes, Your Lordship.
अपन बंदे कौन decide ही नहीं किया appear क्यों ना कौन? Mr. Padi is not there.
No, Your Lordship. Your Lordship may give us short adjournment.
We are just keeping this matter to after you decide yourself who is to place the matter for Union of India.
Lordship, I'll seek instruction.
On special on being mentioned by Swan Sudha na likhiyo. Acha, aanko na likhiyo, Mr. Madam P.R. Burma. This case is adjourned to after ensuing winter holiday. Yes, next.
Item 5.
Item 5 will Lordship may kindly be taken after vacation.
Well, you are mentioning on behalf of
petitioner.
You are Nirod Kumar Sahu?
No, sir, not mentioned.
You are an associate of the firm. Please give your name.
Yes,
So and so appearing for Mr. Nirod Kumar Sahu, 6 for an adjournment after ensuing labor holidays. Yes.
Item 6.
May I please, Your Lordship? Already in this case, the petitioner of the Union of India challenged the order of the Lord Tribunal. My Lord, unlike the original application of the petitioner, Lordship kindly have a glance to page 81. It is the impugn direction. Questioning the order of removal from service.
No, you come to your prayer portion. The prayer is that you are challenging the order dated 30/10/2024. Where is that order?
That is only that is
Annexure 3.
Annexure 3, it is mentioned as 9/7/25.
Order date is different.
I don't know, who will define the order date? Prayer को देखो अब annexure 3 को देखो अब आपण को prayer को देखो किछि जदि सेमति किछि order अछि कारण annexure 3 को आपण लेखुजंती annexure 3 is dated 9/7/25. You do one thing, you just make a short application, an interim application to amend it, right?
I'll do it.
Mr. Mahapatra, learned senior panel counsel, submits that though in the course title he has mentioned that it's a writ application challenging the order dated 9/7/25 of the Land and Central Administrative Tribunal in way number so and so, and the said order has already been annexed to the repetition as annexure 3, but inadvertently in the prayer portion it is mentioned that the order under challenge is dated 34/2024, passed by the Land and Central Administrative Tribunal in the aforesaid way. And therefore, 30/10
is your prayer.
Is your prayer. And therefore, he intends to file an interim application to amend the prayer portion. This matters after the ensuing winter holiday. If any interim application is filed in the meantime, the same shall be placed on record.
Sorry, my Lord, inadvertently.
No, it happens, but all I do is.
Item 7.
Mr. Mahapatra,
Lordship, I have instruction I appeared for the appeal parties, Lordship. In this
have you received the copy of the writ petition?
Yes, Lordship. My office has received the copy, and I received.
Office মানে কোন copy
Office is DSG.
তুই দিয়ে আসছেন না কোন?
No, I have the copies with me.
Even at the council.
You are from appoint party number 2 and 3.
All the appeal parties, Lordship.
All the appoint parties.
বিশ্ব বিহারী মহান্তি তো পাঁচ ওভার করুন তো কালে আসতে
Item 8.
Item 8, Your Lordship. Your Lordship, one WPC number 35530 of 2025 has been filed against the same order, Your Lordship. It may be tagged along with the present case, Your Lordship.
There are number of original applications which were disposed of by common judgment or order.
Yes, Your
And
Lordship.
that is being challenged by different writ petition.
Yes, Your Lordship.
So,
But
one of such WPC is what is the number?
35530 of 2025.
30 of 2025.
Yes, Your Lordship.
Left on the.
My Lord, I have instruction to appeal.
Dion. You are Mr. Milan Kumar.
Yes, Your Lordship.
Mr. Milan Kumar, Land Central Administrative CGC, Central Government Council, submits that the impugned order in this case is dated 19/6/2025. Passed by the Land and Central Administrative Tribunal, Cuttack Bench, Cuttack in way number 98 of 2020. Mr. Counsel, what is your page number 2 of the order?
Lordship,
29 page kind of missing করছি না ভুল রয়েছে
29 page is starting from orders onwards.
28 ପରେ 30 ଅଛି ସେଟା page number 3 ସେ 2 number page ଟା ନାହିଁ ତା ମାନେ ଅଛି
ଆମ ପାଖରେ ଅଛି we have
29 ତାପରେ 32
ତାପରେ ଆଉ ଟିକେ ତଳକୁ ପଳେଇବ।
28
ହଁ
30 ଆଚ୍ଛା ଆଚ୍ଛା ଠିକ ଅଛି alright କଣ ଲେଖିଲେ
I made it.
and you say the similar matter is under challenge.
Yes, Your Lordship.
Similar.
Because this is a singular OA which has been disposed of, not that a number of OA was tagged together and common judgment was
My
passed.
Lord, relying on the
Single
same
OA.
order, Your Lordship, it has been.
That you say. In
Yes.
similar matter, the order passed by the Learning Central Administrative Tribunal is under challenge before this court in WPC number 3553.
35530, Your Lordship.
Yes, 35530 of 2025.
Yes, Your Lordship.
Which is sub judice. And therefore, this matter may be tagged to the aforesaid writ petition. Stop. Mr. Nirmal Chandra Ranjan Raut Rai and his associates have entered appearance for the opposite party. Let a and filed wakalatnama, which is taken on record. Let a copy of the writ petition be served on Mr. Raut Rai and matter be listed after ensuing Xmas holidays, showing the name of the Learning Council for the opposite party in the cause list. Name. Yes.
Item 9.
Batch of cases, I think, Your Lordship, past orders, along with this case, to present today's case, to be listed on 21st past, but somehow it had come. Also look to the last order, third page of that order.
This is in
Sir,
some other case.
31996 have been directed to listed along with that. That's the kind look to that. That's referred my name. So now
It's all right, but we have stated number of matters to be listed.
I'm listed along with this case also 31996.
Today's that is to be listed. Acha 21 mane.
Oh, this is also included. But it has
21/1/2026 ରେ list କରିବ
wrong.
ଆଚ୍ଛା ଇଏ ଗୋଟେ ଆଗରୁ ପଳେଇ ଆସିବ
ये बैच केस चलता है
ଲେଖନ୍ତୁ Mr. Rautel and senior advocate appearing for the petitioner submits that in WPC number 20325 of 2014, which is a similar matter, order has been passed on 19/11/2025 to list this matter, so also the other writ petitions along with this said writ petition, and the case was posted to 21/1/2026, and therefore this matter may be listed on that day. He files the copy of the order passed in WPC number 20325 of 2014, which is taken on record. List this matter along with WPC number 20325 of 2014 and other connected matters on 21/1/2026.
Item 10.
Item 10, a paper short adjournment. A paper short adjournment.
You are appearing
For the petitioner.
The Learning Council for the petition of Mr. Panigrahi seeks for an adjournment. Please this matter after Xmas holiday. Yes.
Item 11.
Please, Your Lordship, my Lordship. Here the petitioner is the Union of India and the other petitioners are the functionaries under the Union of India. They had aggrieved by the order passed by the Odisha Central Administrative Tribunal, more so by the clauses 9C and E of the impugned order, wherein the leave encashment amount has been, the interest is being charged on the leave encashment amount, which is per se not as per the office memorandum as well as the
Mr.
leave encashment.
Panda,
My lords.
in such type of matter where the order of the London Central Administrative Tribunal is being challenged here, we insist that not only the original application but also the counter affidavit, rejoinder, if any, be filed.
Yes,
So
my lords, I've
you have
filed
only
the-
filed the copy of the OA, but it seems from the impugned order that counter affidavit has also been filed because paragraph 4 it appears that counter affidavit has been filed. So
Well,
where is your counter affidavit?
It's that I will file.
Just file it,
My
okay?
lords.
Uh,
And the original order I have annexed, my lords.
no, that's all right. And there is a standing order to that effect that wherever that is
I interest for past time issues. That's okay.
Let's continue.
Yes.
Mr. Sudipto Panda, Land and Central Government Council, submits that inadvertently he could not file the counter affidavit filed by the Union of India in the uh, original application, and some time may be granted to file the same. Put up this matter after ensuing winter holiday. Yes.
Item 12.
অনুপ উদয় সেনাপতি নাহাନ୍ତି আচ্ছা 500 করন্তু কার আছে
Item 13.
Item 13.
Yeah.
So, Mr. Manan, pass on.
500.
Achha.
All right, next.
Item 14.
People sought adjournment, Your Lordship.
You are mentioning on behalf of the petitioner.
My lord.
You have got power in this case.
My lord, my lord.
What is your good name?
Parsuram Panda, P. Panda.
P. Panda.
My lord.
Mr. P. Panda, Land Council, appearing for the petitioner, seeks for an adjournment. Please this matter after ensuing Xmas holiday. Yes.
Item 15.
Korpita Gornay. নাহাନ୍ତି 500 করুন।
Item 16.
16 Mr. Sushant Kumar Naik. নাহাନ୍ତି 500 করুন।
Item 17.
अरे ये देखो जो कौन सा ये डिस्प्ले ठीक ठाक देखो जो ना 17 is Mr. Mishra.
My lord, 1718 in Lordship, my lord, kindly see Lala's order dated 12/12/25.
On pass for Filu.
Again.
The writ petition has been filed by Swan from disposal of this on person. Submit that opposite body have rendered and they have also filed the request. Land Council for the further some case is now posted council. If there is no impediment, the expected round CGM shall prior to disposal. The proceeding on the section 1 and the tax you are on the batch of it which is stated for the communicated by the Land Council for the state to the government in town. And in turn, the government has communicated all councils.
My lord, kindly see what order she has passed.
Same day, we have intimated the office of the Lieutenant CJ through his clerk, Kannucharan Vishwa. He has received the notice, but yesterday he intimated that Lieutenant CJ did not want to intimate to this office of the advocate because there is no specific direction. With due humility, I am to submit.
कौन ऑर्डर करछनी लास्ट डेट रे आगे पूरा पूरा एडजुडिकेशन टाइप रो करछनी so I am my simple prayer before your lordship is as per law they may dispose it of they कहछनी NCL रे ऑर्डर रे आगे पैरा 3 जो देखो तो एडजुडिकेटरी प्रोसेस बढ़िया
administrative work.
your lordship knows
But some order has been passed, Mr. Yeah, this is to be, it is not this way you have to bring it on record.
No, I'm sorry, my lord. Only I was indicating, my lord, in spite of your lordship order, relying on your lordship giving directions, my lord, and if your lordship will recall, this earlier judgment of your lordship in a batch of matters.
That is reflected in the order.
Again, I'm giving for refreshing my lord's memory, 2 copies I'm giving. Because your lordship's own order was there, because many cases were being filed by multiple banks. These are copy. The earlier judgment your lordship have given, again I'm giving. The lordship had laid down certain guidelines.
No, that is what
That again I'm giving to your lordship. That simply has to dispose of my lord. You may reject it if the CM sees that if there is no merit in the case or whatever, if there is a very bar, may reject it.
The basis of affidavit disclosing the sanction amount due to pay at the 13.2 and 13.4. Then they have to do no requirement of notice to opposite party or other party.
Your lordship, the decisions I have also got of the apex court. Your lordship knows that lordship wants I can show them.
No,
it is there.
Only disposal I am praying, not on merits.
Yes.
I cannot come before merits because
If the court finds that any material is lacking to pass an order under section 14, compliance can be directed. But in absence of that, court should pass an order.
And not the decisions of the apex court also I am giving to your lordship.
No need, sir.
Your lordship knows that. I have got only manner to satisfy myself. 3 decisions I have got. Simply it is a non-adjudicatory process. It is a ministerial work. And keeping in the statutory time limit.
Was passed after the our order dated 12/12/20.
Yes.
Now when the
it is posted to 26th again, my lord. If he feels that there is some bar under some special law or something, he may reject it, my lord.
ଆଉ ଟିକେ ଲେଖିଦଉଛି ଯଦି ହବ ସେ ଡିସ୍ପୋଜଲ ନ କରିବେ ତାହେଲେ ଦେଖିବା
ଆଜ୍ଞା 126 dispose of as
the report has already order of this and communicated as reflected.
ଲେଖୁଛୁ ଆମେ period the order dated 12/2025. ଆମେ କହିଥିଲୁ ରେଜିଷ୍ଟର ଜୁଡିସିଆଲ with the CGM ସେ କମ୍ୟୁନିକେଟ କରିବାକୁ ଭଲ କି
ଆମେ କରିବୁ ଆଜ୍ଞା ସେ ଅର୍ଡରଟା
ଇଏ ଆମର ରେଜିଷ୍ଟର ବି କମ୍ୟୁନିକେଟ
CGM register ଜମା କହିଲେ
along with the order.
by the ଅଛି letter as per order dated this court along with past insurance and as communicated to the reliance by the CGM. This has been communicated for the time. ଅଛି CGM କୁ ଆମର register judicial ଦେଇଛନ୍ତି ଚିଠି ଅଛି compliance of this one, so please find your attached with this one. So ଦେଖନ୍ତୁ it appears that as per the order dated 12/12/2025, we asked the Learned Chief Judicial Magistrate Cutter to dispose of the proceeding under section 14 of the SIR instituted at the instance of the petitioner bank. Keeping in view the order passed by this court in WPC number 10628 of 2025, bracket A, Bank of India, Hon'Ble branch versus State of Orissa and others, and a batch of writ petition. As per the said order, the Learned Register Judicial of this court is also communicating the order to the Learned Chief Judicial Magistrate Cutter. Along with the copy of the order dated 21/7/2025 passed by this court in the aforesaid WPC number 10628 of 2025. Mr. Mishra Land Counsel appearing for the petitioner submits that the bank has also brought to the notice of the court and notice of the CGM about the order that was passed on 2025. In spite of that, on 17/12/2025, when the matter was taken off, the Learned CGM Cutter has passed an order as if he is adjudicating an issue in this matter, and he has brought to the notice of this court. He has filed the certified copy of the order dated 17/12/2025. According to Mr. Mishra, the ଆମେ କୋର୍ଟ କରିଥିଲୁ ଆଧିରେ ନା ସେ ଆଗ ଅର୍ଡରରେ କୋର୍ଟ ହେଇଥିଲା ନା ସୁପ୍ରିମ କୋର୍ଟ ଡିସିସନ ଅଛି ଆପଣଙ୍କ ପାଖରେ
ଆପଣଙ୍କୁ ଦେଇ ଦେଇଛି ଦିଟା କପି ଆଗ ଡିସିସନ ଦିଟା କପି ଦେଇଛି
in view of the scope of section 14 of the Surface IR, which has also been dealt with by the Honorable Supreme Court in the case of RD Jain and Company versus Capital Fast Limited, reported in 2023-1 SCC 675. It is just a ministerial act, and it has to be disposed of within a stipulated time limit, keeping in view the spirit of the special enactment. According to Mr. Mishra, that when this registry of this court, in compliance to order passed by this court on 12/12/2025, has communicated the order passed in the WPC number 10628 of 2025, where the aforesaid decision of the Honorable Supreme Court has been found mentioned. The Learned CGM should not have passed the order dated 17/12/2025 in the manner in which it has been passed, and which rather shows that his as if adjudicating any dispute between the parties. Be that as it may, subparatory, since from the order dated 17/12/2025, it appears that the date is posted to 26/12/2025. It is expected that the Land CGM, keeping in view the observation of the Honorable Supreme Court in the case of RB Jain and Company Supra, also in WPC number 1068 of 2025, dispose of
As per law.
Section 14 application in accordance with law. Put up this matter after ensuing winter holiday. The Learning Council for the petition has clarified this court about the development made in the meantime. Copy of today's order shall be communicated to the Learning CGM by the registered judicial during course of the day. Yes.
Next case also same, the certified copy.
17 and 18.
17,
18. Certified copy again. Same thing, same order is to be filed.
So that be same. Yeah.
Obliged.
Okay. Really? I would. Next.
My pleasure. The present petitioner application on section 14 before the collector Ganjam, madam.
Pending.
No, madam. My order dated 1/2024, madam. Though order was passed on section 14, but till date, my lord.
order टा ହେଇଥିଲା ପଢୁନାହାନ୍ତି
My lord,
Annexure 1 ତ
my lord, where I am satisfied from the application of the authorized phonics private limited.
Therefore, in next.
Therefore, in exercise of power conferred under section under section 14 of the Securitization Act, my lord, Divya Jyoti Panda, IS Collector as District Magistrate Ganjam, do hereby accord permission to take possession of secured asset, building standing and such, title number such and on or before 7/2/2024, and hand over over to the authorized officer for next department for private limited.
ଏବଂ ଅନ୍ୟମାନଙ୍କୁ ଡାଇରେକ୍ସନ ଦିଆହେଲା ଯେ ବର୍ତ୍ତମାନ ଆପଣ ପ୍ରାୟ 1.5 ବର୍ଷ ହେଇଗଲାଣି 1.5 ବର୍ଷ ବେଶୀ ହେଲାଣି କୁଆଡେ ଯାଇଥିଲେ ଆପଣ କଣ ହେଲା
ତାପରେ ସେଠି law and order situation କଣ ହେଲା ତାପରେ SP
ଏଇଟା ତ we just want to know that the if that was directed to be given on or before 7/2/2024, what happened thereafter? What is
thereafter my lord no effective step
କଣ ଲେଖିଛନ୍ତି ରିଟ୍ ପିଟିସନରେ କଣ ଲେଖିଛନ୍ତି
ମୁଁ ଲେଖି ସେ କିଛି ନଉନାହାନ୍ତି
No. What step you took thereafter?
I have approached several times, madam.
What is that? What is the mode of your approach?
ଆପଣ ତ ଖାଲି ଗୋଟେ ଅର୍ଡର କପି ଦେଇ ପଳେଇଲେ ନା। ଆପଣ ଯଦି କହୁଛନ୍ତି 7/2 ରେ କିଛି କ୍ୟାରି ଆଉଟ୍ ହେଲାନି ଆଉ ତାପରେ ଆପଣ ସେଇ ମାନେ ଡିଷ୍ଟ୍ରିକ୍ଟ ମାଜିଷ୍ଟ୍ରେଟ କୁ ଆପ୍ରୋଚ କରିଥିଲେ ମାନେ କଣ ଠିକ ନା ଫୋନରେ କହିଲେ?
No, madam. Personally, I am met, madam, by the authorized official.
How can it be? You are an institution, sir. You are a establishment. How can you personally over phone or physically you will ask SP to?
I am not filing the way you have filed the Section 14 application. File that your order has not carried out.
Your lordship may grant me some time. I will file.
You would have collected the information from the SP, the sub-collector to whom he has directed that you ensure provide the adequate police personnel. So it must be brought to the notice of the concerned authority that you have passed the order that has not been carried out. And
well, I will file by affidavit what step I have taken after 7/2/2002. 1/2/2002.
We are directed. By the way, you take also the instruction. The writ petition has been, but it is still sub judice.
Yes, ma'am.
The writ petition has been filed by the petitioner, so and so.
If individual has not been carried out, SP को direction
सुंदरती को से जारी करना तो
कर दी तो
नहीं, as per my instruction, madam, no.
But how can we know?
Your lordship may direct, if not.
No.
My lord. Yes, sir. Your lordship.
Obtain the entry.
My Raj, your lordship.
So and so. For a direction to the SP Ganjam to give proper protection and hand over the civil property to the petitioner after taking physical possession of the property situated over as per the order passed in Swansea within a stipulated period. The learned counsel for the petitioner to the attention of this court to the order dated 1/2/2024 passed by the opposite party number 1, collector and district magistrate in an application under section 14 of the surface IR filed by the petition, and it seems that the collector has accorded permission to take possession of the secured assets, that is building standing over so and so on, to the authorized officer of the petitioner on or before 7/2/2020, and the copy has been forwarded to Superintendent of Police Berhampur with a request to provide adequate police personnel for taking over possession, and also to sub-collector from SDM Berhampur to deploy an executive magistrate on the above spot for maintenance of law and order. ତାଙ୍କର ଗୋଟେ ଥାଏ ସେ ଯୋଉ ଏଇ ଟାଇପ ର ଡାଇରେକ୍ସନ ରେ ଏସପି ପାଖକୁ ଗଲେ ଆପଣଙ୍କୁ ଟଙ୍କା ଡିପୋଜିଟ କରିବାକୁ ପଡେ ସେଟା କରିନଥିବେ
by that time, my lord, the date can have class February. Thereafter election. There must be some gap, my lord. The petitioner may be directed to file an affidavit. What step he has taken?
We are directed, he submits that in spite of such order, the petitioner he has not yet got the possession of the secured assets. When we posed the pertinent question to the Land and Council for the petitioner, that if by 7/2/2024 the petitioner has not got back the possession as per the order passed by the by the opposite party number 1, what further steps he has taken before the opposite party number one in that respect. Land Council submits that will obtain specific instruction that if it file affidavit. Stop. Let the Land Council for the state also obtain instruction relating to the status of the proceeding under section 14 of the Surface Act, which is registered as MC bracket account to bank 02 of 2023. है ना? Put up this matter after Xmas holiday. Yes.
Item 20.
It may please your lordship. Item 20, my lords, the section 14 application is pending since 18/9/2023, my lords. Before learned CGM Khurda.
CGM Khurda?
My lord.
Order sheet dekchandi.
Again, annexure 2 is the order sheet, my lords. Entire order sheet is.
Order sheet
annexure 2.
Number of time the petitioner remain absent.
No, only once is there. Otherwise, all the due to the administrative.
Recording evidence of the witnesses pronouncing the judgment in sessions kitacha. See busy achieve. The court is busy in recording evidence of the witnesses. Time file করছি তাদের টাইম লিমিট ଅଛି তাদের এই ଯୋଉ ଆର ପୂର୍ବରୁ ଗୋଟେ ଅର୍ଡର ଥିଲା ସେଟା ନେଇଛନ୍ତି ତାদের ସେ ଡିସିସନଟା କୋର୍ଟ ହେଇଛି ଯେକି ଫିକ୍ସ ଅପ୍ କରିଛନ୍ତି ଟାଇମ ଦେଖୁଲ ତାদের ତାଙ୍କ ପୂର୍ବରୁ ଯୋଉ ଡିଟେଲ ନେଇଥିଲେ ତାদের ଗୋଟେ ଅର୍ଡର ମଧ୍ୟ ଦେଇଥିଲେ ଆମର ମିଷ୍ଟର ସୁବ୍ରତ ମିଶ୍ର ଦେଇଥିଲେ the Supreme Court decision to record item number 17 here. Look, this petition has been filed by Bank of Baroda with a prayer for a direction to dispose of this case number so and so filed under section 14 of the Surface Act within a stipulated and time-bound period, and also and to pass all necessary consequential orders for taking over physical possession of the secured assets. Mr. Niyamati Land Council appearing for the petition submits that even though this case was filed in 2023 on 18th April, September 2020, but till date there is no such progress in the case, and in support of such contention, he has annexed the entire order sheet passed by the reliance regime as annexure 2. In the section 4 of the letter export for the relevant, Supreme Court states like this, and the ministerial act particularly. In view of such a ratio laid down by the Honorable Supreme Court, since the matter is sub judice since 2022, we direct the Lenant CGM Khurda to expedite the hearing of the so and so and dispose of the application at an earliest by end of January 2026, according to the petition is disposed of. Yes.
Obligement.
Item 21.
Yes. For the petition.
Yes. What is your prayer?
Not actually.
13-4 notice you are challenging.
13-4 was challenged in DRT
of Orissa in court.
What happened?
Subsequently, that surface application is disposed of. On the observation, due to devoid of merits, the application is disposed of, including all IA application.
Then what happened?
Being dissatisfied, fine, plain, without having any direction, without having any remedy to the applicant.
Then what happened?
Then I being dissatisfied, being aggrieved by and dissatisfied with that order, I intended to file appeal before the appropriate authority.
DRT.
My lord.
No.
Accordingly, I contacted with my learned advocate, who advised me to file a writ petition before this honorable court. Accordingly, on 4th December, just 5 days delay, I filed a writ application before this honorable court, which was ultimately disposed of on 12th December.
As withdrawn.
As withdrawn, not for filing a perfect proper application. And subsequently, I also instructed my learned advocate to take appropriate steps for filing the appropriate application before the appropriate forum.
DRT.
I don't have any knowledge. I am a layman. I don't have any knowledge.
It's all right. Then
I have instructed my lawyer to take appropriate steps. With due leave of the honorable court, my learned advocate appeared and withdrawn my case on 12th December.
Withdrawn?
My case, writ petition, the earlier
that is there.
On 12th December.
Proceed.
Subsequently, I again instructed my lawyer to take appropriate steps. That would have been filed before the DRT. But I don't have any knowledge. I have a layman. My learned advocate subsequently, due to wrong conception and a lack of legal acumen, unfortunately filed another writ application before this honorable. That was filed on 28th Jan 2025, and that was disposed on 4th March.
So again, that matter was
my lord, again that mistake.
That again you are asked to go to the DRT.
My lord.
Then what happened in the DRT?
Subsequently, on 17th April, I filed a fresh. I contacted with a lawyer in Kolkata. And because the DRT bench is situated in Kolkata.
Yes.
And on 17th April 2025, I filed an appeal under Section 18(1) of the Sufficiency Act. That application was
dismissed on the ground of limitation.
Yes. Hard on length.
Yes.
And on 17th November, it was.
So, what is your delay condonation application?
Minor. That was. It has been observed that it was my luxury to consume the day and to.
Where is the delay condonation application which have been filed before the DRT? What ground you have taken?
Minor.
Number one. Number two, whether the DRT has power to condone the delay or not.
Minor.
All the things I am for the auction purchaser. All the things have annexed in page number 117, and order has been pronounced in the open court on 17/11/2000.
I filed that appeal under Section 18(1) before the DRT Kolkata with limitation application along with all other statutory applications which are required to be filed. The leave petition, waiver application.
Come to the input order. Land Council, you please come to the input order, page number 120, paragraph 9.
Madam.
In a recent judgment, read it.
Page number?
Page number 120. Running page in 120, internal page is 4 of Annexure 13 series.
Madam. Page number 120.
Paragraph 9.
Madam. In a recent judgment in Sivobhama date by LRS versus Karnataka Housing Board, the Honorable Appeals Court has held that appellant is not only required to explain the delay after expiry of the statutory period of delay. Rather, he is required to explain the delay from the date when limitation is running, meaning thereby appellant has to explain the delay right from the day one when the impugned order is fixed. I am also inclined to that. I have
Please
filed
read it
that
out the order.
application, my lord.
Land Council, please read it, complete the order.
Paragraph 9. Next, in the present case, if we can grant benefit of Section 14 Limitation Act to the appellant for the period from 28 January 2025 when the writ petition was filed till 4th March 2025 when the same was disposed of, and after 2 weeks, that is 18 March 2025, we have to see as to whether the appellant has explained the delay right from the date of passing the impugned order, that is 30th October 2024 till 28 January 2025 or 4th March 2025 till the date of filing the appeal, that is 22nd April 2025. At the very outset, it is to be observed that in the Section 5 application, not a single point has been stated about the delay caused after the time granted by the Honorable High Court in the order dated 4th March 2025, wherein 2 weeks' time was granted by the Honorable High Court, but the appellant did not avail the opportunity granted by the Honorable High Court. Appellant filed the appeal with considerable delay after expiry of 2 weeks granted by the Honorable High Court without giving any explanation for delay. My lord, para 12, as far as period from the date of the impugned judgment and order, that is 30th October 2024 till 28th March 2025 is concerned, appellant has annexed certain documents of medical treatment which shows that appellant number 2 was admitted in hospital on 30th December 2024 and was discharged on 8th January 2025. Impugned judgment and order was passed on 30th October 2024, meaning thereby even if we accept the statement made by the learned counsel for the appellant regarding illness of the appellant number 2, that too could not be of any aid to the appellant as appellant number 2 was admitted in hospital after about 2 months for surgery of hernia and was discharged on 8 January 2025. Law protects the litigant who is vigilant about his own right, but luxurious litigation cannot be permitted to continue. There is nothing on record explaining the delay in preferring the appeal. Although appeal is filed after considerable delay, no sufficient cause for delay could be shown by the appellant. I don't find any ground to condone the delay in filing the appeal. Section 5 application lacks merit and is liable to be dismissed.
Yes.
Para 14, IA 331 of 2025 is dismissed. Consequently, appeal.
So, what is the illegality in this order?
My lord, I am coming to that point, my lord. Actually, the point has been raised in this order. That is on 28th January, which I wrongly filed before the wrong forum, according to the instruction of my.
Well, Mr. Counsel, I was asking you that first of all, you have not filed that delay condonation application.
No,
and of course, it has
before DRT.
Before this court.
My lord,
in the writ petition.
I'm sorry, begging pardon, my lord. I'm begging pardon, my lord. Let me have an opportunity to file a supplementary affidavit so that I can annex this application, my lord. I'm begging pardon.
This writ petition has been filed.
Let me have an opportunity to file all such application before the
petitioners challenging inter alia the order dated 17/11/2025 passed by the Learned Safe Recovery Appellate Tribunal at Kolkata in appeal DUI number 417/2025, which arises out of SN number 15 of 2018 passed by from the DRC cutter bench cutter. It seems that An interim application was filed by the petitioners under Section 5 of the Limitation Act, which was registered as IA number 331 of 2025, for condoning the delay in file the appeal. And that application was dismissed by the current DRAT, and consequently the appeal PY number so and so was also dismissed as time barred. After arguing for some time, learned counsel for the petitioner seeks adjournment to file the delay condonation application, which was filed before the DRAT. And serving a copy of the same on the learned counsel for the opposite party, Bank of Baroda, put up this matter after ensuing winter holidays. Yes, next.
My lord, being an capital, my name kindly be grateful.
Tuna Sao Para Lekhai?
No.
Acha, Mr. Swanso is present for the opposite party. Yes. You have received the copy of the writ petition?
Yes, my being an capital, they have solved.
All right.
Item 22.
Grateful, my
Mr. Panigai? What is this writ petition for?
The petition is for the implementation of the Section 14 order in view of the judgment of this coordinate bench of this honorable, which was to be done within 60 days. The judgment annexes Annex 1. But taking Lordship's query in another matter, that have you, after the order is passed, have you contacted the magistrate? I consider that we
have an order dated 18/9/24.
My lord. So thereafter, in writing, we have not contacted, honestly submitting. If a lordship consider my submission, within a week we'll approach the magistrate, and in writing, thereafter, the 2, 3, 4 weeks, whatever lordship thinks fit, they can implement the order. If a lordship may kindly see the judgment of this honorable court, which is 60 days time to implement.
No, that is
already there in the statute.
It is there. The statute is there. Ame Supreme Court ko decision to kori tam kahithilu je udago deri kariboni. These are all being. But here an order was passed in your favor. That means the superintendent of police was requested to provide so and so, like the other case also, and that was passed in September 2024. We are in December 2025. So what we are saying that if you have not approached thereafter to the collector for, because the order has been not implemented, maybe for some of your latches, because as we are informed that some amount is required to be deposited with the superintendent of police for implementing deployment of the police force.
One of the matter is still pending before a lordship. Lordship also asked the other party that under which provision you are asking the money. So that is still pending. That has not been.
No, this is
for deployment of
police force, and you are a private one. You are a private bank or whatever it may be. So anybody can. So why the police personnel will be sent as such? It is if they have stated that. But you have admittedly you have not done anything.
That is my. I have checked with my client also beforehand. So they will approach the land magistrate within a week time, and they can implement with it.
We all right. We were disposing of the writ petition. This writ petition has been filed by the petitioner, so and so, with a prayer for a direction to the opposite parties, to implement the order dated 18/9/2024 passed by the Ilan District Magistrate Collector and District Magistrate Cutter, that is opposite party number 1, with a further direction to the opposite party number 1 to take possession over the secured asset and forward the same to the petitioner. From the order dated 18/9/2024 passed by the opposite party number 1, which is annexed to Annexure 2, it reveals that the collector has passed the order requesting the superintendent of police Ral Cutter, that is opposite party. Aaj kar din na opposite party. What's the number?
That is not OP2.
Opposite party number 2 to provide necessary police assistance to the secured creditor, bracket like them, the petitioner bank. And the sub-collector Sadar Cutter, aaj kar din party.
OP1.
No,
sub-collector party.
Sub-collector is not party.
Not a party. Sub-collector is directed to deputy magistrate at the same time for the physical position at the time taken over physical position of the secured asset as per section 14(1) and 2 of the Surface Side Act. Date किसी fix up करते ले?
नहीं किसी पर नहीं
The Lieutenant Counsel for the petitioner submits that even though after passing of such order, a year and 3 months have already passed, and there is time specified under section 14 of the Surface Act regarding delivery of position, but the same has not been done. However, when we made a query to the Land Council for the petitioner as to whether after the passing of the order under Annexure 2, whether any further approach has been made to the opposite party number 1 regarding the non-taking over the possession of the secured assets and handing over to the petitioner. The answer was in negative, and Land Council for the petitioner submitted that necessary application to that effect shall be filed before the opposite party number 1 within a period of 2 weeks with a copy of this order. There is no dispute, as we have observed in the case of so and so, the previous order achieved. Subrat Mishra item 17 order pass the Supreme Court decision court. It's a ministerial act and it's time stipulated sponsor. In view of such a ratio laid down by the Honorable Supreme Court and the order passed by this court, it is expected that if any such application is filed by the petitioner within 15 days, the opposite party number 1 shall do the needful in accordance with law. Accordingly, the writ petition is disposed of.
Time limit will be
that converting by end of January 31st. Yes.
obliged. Next item same, I think because 23 years.
23 cents.
Obliged.
Item 24.
The petitioner will be directed to produce the certified copy of the order before the
petitioner is directed to produce the certified copy.
With the application
and the free copy of the order we hand over to the Land Council for the state or district magistrate.
obliged.
Item 25.
24.
Item 24.
This writ petition is against the order of Lawrence Central Administrative Tribunal. I filed the OA before the Lawrence Tribunal challenging the order of the authority, rejecting my prayer for compassionate appointment. I prayed for compassionate appointment for my son, which was rejected only on the ground that your family is not in indigent condition. Not in indigent condition. Family is not in indigent. Then Lawrence Tribunal also accepted the view of the authorities and rejected my original application, indicating that since your family is not in indigent, therefore you cannot get the compassionate appointment. But Learned Tribunal failed to appreciate my case because my case is something different. That authority cannot reject my application on indigent condition, and the Learned Tribunal cannot also accept the same because my case is totally different from the facts. In normal circumstances, this is acceptable, I do admit. But in my case, this is not acceptable because your Lordship may kindly turn to page 38, that I took the VR. And this is the office order dated 9/1/2020. I had 10 years of service, but I took the VR due to medical decategorization. Your Lordship may kindly see, may I place, yes. 3 lines only. Consequent upon the tendering of voluntary retirement from service, Sri Binod Kumar Pradhan, son of Gopinath Pradhan, such and such, filed his application dated 25/11/2019 with approval of the competent authority dated 8/1/2020. The said voluntary retirement is hereby accepted from the prospective date such and such, such and such. Your Lordship may kindly see my application. This is 25/11/2019. What application I have submitted, Your Lordship may kindly turn to page 27, Page 27. This is 25/11/2019 application on the basis of which this order was passed. Your Lordship may kindly, towards last paragraph, Your Lordship only kindly see. Therefore, I humbly pray to Your Honor may kindly consider the above facts, and I may be allowed to retire from service on VRS ground, and in my place, if my only son Vinayak Pradhan will get the job on compassionate ground in the railway department, so that he will maintain the entire family members out of his income, and he will also looking after me. This is the offer with the condition, Your Lordship, I am only relying, exactly in similar issue, the Honorable Supreme Court has said, exact on similar issue.
No, what is so far as suppose somebody is taking VRS and he puts this type of condition.
What is the scheme?
What is the scheme?
Railway scheme is there,
Yes, for what?
Where is that scheme?
Where is that?
See that? Because the decision may be on a different state of fact, but we have to see that
if the scheme allows.
Yes,
Where is that?
Your Lordship may kindly see RB Railway Board's establishment circular,
Annexure?
No, annexure sir seta nahi thala seta refer hai setire. Your Lordship, I am copy ta dou jaga RB ra copy. RB 78 of 2006, Your Lordship may kindly see. Paragraph, next page, paragraph 4. Pursuant to demand, may I place,
Yes.
Pursuant to the demand raised by the staff side, the issue has been deliberated upon at length in full board meeting, and it has been decided that compassionate ground appointment of wife, wards, dependents of partially medically decategorized staff who seeks voluntary retirement may be given subject to the following provisions. The appointment will be given only in the eligible Group D categories. Eligible would mean that case of Group D retirement is banned for any particular category. The same would also apply for the compassionate ground appointment. Such an appointment should only be given in case of employees who are declared partially decategorized at the time when they have at least 5 years of more service left. CMD of the railway should keep watch over the trend of decategorization so that present figure do not inflate it. CMD should also get 10% partially decategorized cases re-examined by the another medical board not belonging to the divisional hospital which initially declared them to. That means there is a provision for giving the compassionate appointment. Before my retirement, 10 years service, before 10 years of service of my normal retirement, I took the VR.
So you must have placed this also before the, how the tribunal has dealt with it. The counter going.
Your Lordship may kindly
come to the counter first. You have relied upon this RBE number 78.
78, Mila.
In your original application.
Mila.
Then what is your reply in the counter affidavit?
They have not, in fact, my case.
Upon stand neitile ki. See your first, your proceedings. Yes.
OA, Mila. OA is at page 29, Mila. Mila.
49.
29.
29 say relevant due to purchase RB on jai, my son is entitled to so and so. Where have you taken?
Page 35, paragraph 5.6.
अच्छा अपन annexure A by 2 तक करी देइछन.
Again?
Paragraph number 4.6 election.
Again.
On being approved by the Swan State when interested approval dated which 14 item. The Bishop food litigation the upon.
Again?
A Bishop EUTA to rely for two paragraph.
In counter page 53 Lordship is counter
4.4 your Lordship may kindly see.
4.4
that due to medical decategorization from A1 to category to C1, the applicant submitted application on 25/11/2019 to respondent number 3 for allowed to retire from service on voluntary retirement, so also prayed for compassionate appointment to his son in view of RBE number 78 of 2006. The competent authority accepted the voluntary retirement of the applicant on 8/1/2020 from the prospective date 8/1/2020, which was communicated to the applicant by the respondent number 4 by its memo number such and such. Their reply is at page, my lord.
Counter.
Counter.
51. That's what
51.
Yes, page 51, last paragraph onwards. It's a big paragraph. Yes.
It is pertinent to mention.
That it is pertinent to mention here.
Yes. That it is pertinent to mention here that as per RBE 78 of 2006, before that, my lord, para 4.4 reply they have given in blood. No, reply they have given in page 54, paragraph 8. That in reply to the averments made by the applicant in para 4.3 and 4.4.
But we have annexed it in the same paragraph.
It is humbly submitted that the applicant, while working in Locopilot, got medically decategorized due to unfit A1 and CMS KUR has recommended to absorb in alternative appointment in C1 or below category by memo dated such and such, letter dated such and such under annexure R by 1 and R by 2 respectively. Accordingly, the applicant was called for screening for alternative employment on a medical ground which was held on 8/11/2019 and was offered to absorb in alternative appointment for post of crew controller in electrical department in his existing pay. But the applicant instead of joined in the post of crew controller preferred to apply voluntary retirement from railway service by the representation dated 25/11/2019, which was accepted by the competent authority as per RBE number 78 of 2006 and communicated to the applicant by letter dated such and such. They are accepting that this is applicable. 78 of 2006. My humble submission, Milord, when my offer was conditional, once they accepting the offer, they cannot deny the condition, Milord. Your Lordship may kindly see one decision I have given exactly same facts, same thing, and this honorable.
In that case, also alternative arrangement was made.
Yes, my lord.
You have been given an opportunity to engage yourself in alternative post.
Yes.
Yes.
Voluntary retirement.
No. Here there is an option because of the nature of decategorization. You have been offered a substitute post,
yes,
which you did not avail.
Yes,
now what is the fact in that case also?
Your Lordship,
or it was only simply a case of
no. There the voluntary retirement he has taken, and there with the condition in my place my son may be given the appointment.
Here the condition was that the kind of decategorization you have in the medical ground, you have a scope to work alternatively. So that alternative post was also offered to you.
Yes,
and you did not avail.
Yes,
now then at this juncture, when you voluntarily did not opt for the alternative engagement, are you entitled for the VRS and for a compassionate act?
Yes, madam, that is 78 of 2006.
No, 78 of is a clear case of VRS.
No,
under the condition.
Perhaps,
And in no. In that decategorization, you have been offered you have long service, and instead of the post where you were engaged, because of the decategorization in the medical ground, you have scope to work. You did not work.
That 78 of 2006 itself is for the purpose that where the person was given alternative employment and he took the VRS mila. This rule, this 78 of 2006 is for that purpose. Earlier, that was no scope for the railway employees if they have been offered the alternative employment, but they are not accepting. Then, in that case, there was no scope for giving compassionate appointment. Subsequently, in 2006, Railway Board has taken the decision that even if a person offer was made, he is not accepting that offer, has taken the voluntary retirement. In that case, his ward can be considered mila, and that is the provision mila. 78 of 2006.
We have specified in the counter. Let's me keep the page 50 to 51.
That is in the rule itself. The rule was amended to that effect. Therefore, I made the application and they have accepted my application where I have indicated the condition that in my place my son may be given some employment for sustenance of the family. And I am relying upon the decision of the Honorable Appeals Court. And so also the Law and Tribunal in similar situation has already passed the order. That order is there and they have implemented. That is Annexure 6 Miller. Exactly on same ground. That medical ground, one person. Miller? Sir, देइसे आपको. What with that? ମୁଁ ତିନିଟା paragraph again ମାତ୍ର ପଢି.
Paragraph.
Para 12. I have given the flag mark Miller. Here Miller exactly similar issue. That VR has taken and given the application. While giving me VR, my son may be accommodated. FCI said that we don't have that scheme. Your Lordship, what the Supreme Court has said, Your Lordship, kindly see the paragraph 12. When an offer is conditional, the offeree has the choice of either accepting the conditional offer or to rejecting the conditional offer or making the counter offer. But what the offeree cannot do when an offer is conditional is to accept a part of the offer which results in performance by offerer and then reject the condition subject to which the offer is made. Then Your Lordship kindly skip paragraph 13 and 14. Your Lordship may kindly see. When FCI accepted the offer unconditionally and retired the second respondent from service by office order dated 29/7/2000, it was implied that it accepted the conditional offer in entirety. That is the offer made voluntary retirement and also the condition subject to which the offer was made, that is appointment of dependent son to the compassionate appointment, compassionate grounds. In this application, the second respondent made it clear that desired to retire voluntarily on medical grounds only if his son, the first respondent herein, was provided with the employment. If FCI felt that such a conditional application was contrary to the scheme or not warranted, it ought to have rejected the application. Alternatively, it ought to have been informed the employee that the compassionate appointment could not be given to his son because he, the employee, had already completed 55 years of age.
Right.
And
this writ petition has been filed by the petitioner Vinod Kumar Pradhan, challenging the order dated so and so to Land Council for the petitioner. What you are placing before us that application that is annexure?
annexure page 27, annexure 2
Submit placed before us the application submitted by the petitioner before the senior divisional personnel officer, East Coast Railway, Khurda, wherein it has been specifically stated that he may be allowed to retire from service on BRS ground since the medical board has declared him as medically decategorized from A1 to C1. And in his place, his son, Vinay Pradhan, be provided with a job on compassionate ground in the railway department to maintain the entire family members out of his income. The Land Council for the petitioner placed before us the RB number 78 of 2006, which is the Railway Board's order number, of Railway Board's order, that is RB number 78 of 2006, which relates to the appointment on compassionate grounds of ward public spouse of medically decategorized staff on the railways. And it is the submission of the Land Council for the petitioner that in view of such guideline provided in the aposted RB number 78 of 2006, the petitioner's son should have been given a job on compassionate ground, which was rejected and it was challenged before the Central Administrative Tribunal, and very specifically ground has been taken.
Lordship also referred to the RB 3 of 2009 also.
8 of 2006. The counter affidavit has been filed by the Union of India, filed by the railways. And it is stated therein that since the petitioner, while working as the loco pilot (G), got medically decategorized due to unfit in A1, and CMS of the KUR recommended to observe him in the alternative appointment in C1 or below category, and the petitioner was called for screening for alternative employment on medical ground and was also offered to observe in the alternative appointment for the post of crew controller in electrical OK department in his existing company. He, instead of joining the post of crew controller, preferred to apply for voluntary retirement from the railway service, which was accepted by the competent authority and communicated to the petitioner. In the counter affidavit, further stand has been taken that the opposite parties rightly rejected the case of the petitioner in terms of RB number 78 of 2006 after assessing the financial condition of the petitioner. And since law didn't permit, the benefit could not have been extended in favor of the petitioner.
It's paragraph 6 of the RB rules.
The in paragraph 6 of the RB number 78 of 2006, it is stated that while considering such request for compassionate ground appointment, the general manager has to satisfy himself on the basis of a balanced and objective assessment of the financial and other condition of the family that the grounds for compassionate government appointment in each case is justified. Stop. Mr. Ojal and counsel appearing for the petitioner placed reliance in the case of Food Corporation of India and another versus Ramkesh Yadav and another reported in 2007 to Supreme Court cases bracket L&S 559, wherein it has been observed as follows. Quote paragraph number 12, 14, then 18. Learned counsel for the petitioner submitted that since the offer that was made by the petitioner for voluntary retirement was conditional, the authority should not have torn down the prayer made therein in providing a job the son of the petitioner on compassionate ground in the railway department. And therefore, the impugned order is not sustainable in the eye of the issue notice on the question of admission, indicating therein that the matter shall be disclosed of at the stage of
My lord,
admission.
one small submission I have.
File your counter affidavit. The Mr. Pari, then Deputy Solicitor General, and K.
Deepak Gujrat. Deepak
Gujrat and Central Government Council.
Yes, yes.
Appears for the opposite parties. Let extra copies of the petition be served on the Land Council for the opposite parties. Put up this matter after queries, counter affidavit, if any, be filed in the meantime. Yes. You call some Passover matters were there in the restitution letter. Ritra joda Passover tila dakon. Tapre
Passover item number 7.
May I please? Here the order passed by the Learned Central Administrative Tribunal under Annex 7 is under challenge. The short issue which was before the Honorable Tribunal for adjudication was when the main order placing the petitioner under deemed suspension order has been quashed by another coordinate bench of the very same tribunal. How could that suspension order be extended further without any further order passed by appropriate legal forum, higher legal forum?
We are insisting that when you are challenging an order of the London Central Administrative Tribunal, you must file the original application, the counter affidavit, rejoinder if any, all these things. But we see that have you filed those documents?
My lord, I will make a complaint of your lordship standing order. But my lord, only thing is, my lord, this case was filed prior to that.
There is a standing order that you are to comply. The writ petition has been filed by the petitioner challenging the order passed by the London Central Administrative Tribunal, Cuttack Bench Cuttack, in OA number 260/00634 of 2019. The Land Council for the petitioner seeks for an adjournment to file the copy of the original application. Counter file itla?
Yes, my lord.
Counter affidavit rejoinder?
Yes, my lord.
And rejoinder the entire pleading, which was there before the tribunal. In view of such submission, this matter, Mr. Rajesh Kumar Mahapatro, Senior and Central Government Council, Senior Panel Council is present for Union of India. List this matter after Xmas holiday. Yes, next.
Item 12.
Mr. Anup Uday Senapati.
In item 12, I have instruction to appear for the bank, UBI.
When council is not there, what is, madam, tell me name, give it and sleep. None appears for the petitioner on repeated call. So and so submits that he has instruction to appear for the bank. Let a copy of the writ petition be served on the Land Council for the bank. Matter be placed after ensuing Xmas holidays. Yes, next.
Item 13.
Mr. Mishra.
My lord, in this case, I have complied with what so it was filed earlier, but I have in the meantime I have filed all the records. My lord, may kindly see the restriction is filed challenging the tribunal's order, dropping the complaint proceeding.
Which is that order, Mr. Mishra? You are challenging?
Challenging the I have filed a content application for non-compliance tribunal's order, and the tribunal has dropped it.
No, what is that order?
Compliance appeals High Court of Orissa.
Sorry, 262.
262.
262.
Yes.
My lord, may kindly relevant
that contempt petition you have filed.
Yes.
That is okay. CP number so and so. Yes. So your prayer therein was
to initiate a content proceeding because
for the non-compliance of the order dated 13/7/23 passed in OA number so and so. Where is that order dated 13/7/23?
13/7/23. May I submit, my lord, to few lines, my lord? May I submit few lines?
I would have done it.
May I submit some few lines, my lord?
And my friend.
No, that is annexure 12. Mr. 170. You come to 178. Paragraph number 12.
In view of the above discussion, setting position of law, the fact that applicants are similarly placed with the applicants in the case before the Honorable High Court of Orissa and New Delhi, who have been given regular appointment on the ground of parity, they are to be regularized. Decision relied upon by the Land Council for the respondents are not applicable to the fact of the case. Accordingly, the respondents are directed to regularize the services of the applicants from initial date of joining with all consequential benefits. And exercise shall be completed within a period of 90 days from the date of receipt of the copy of the order. And this has also challenged before the Honorable High Court. Honorable High Court has also passed the order. My lord, that is at page 198 or so.
198. Just
around 9.
98.
198.
9, paragraph 9.
9, well.
Please place it.
It is pertinent to mention here that the decision rendered by the High Court of Delhi in Amrish Kumar Supra was challenged before the Apex Court in special petition C number 710/2021, which was dismissed by the order dated 10/12/21, and as a consequence thereof, the same has also been implemented. Therefore, the Central Administrative Tribunal, relying on the same judgment, having passed the order, including this court is not inclined to interfere with the same. As such, the order passed by the Central Administrative Tribunal dated 13/7/23 OA number circumstances is hereby confirmed. The petitioner are directed to regularize the services of the opposite parties from initial date of their joining till consequential benefit with a period of 60 days from the date of receipt of the order.
Obviously, it is Union of India who challenged it, the order. So what happened when there are failures? The petitioners were regularized in a MTS post, which is non-existent post. So they were were directed for this regulation and the services they have rendered. And the services they are rendering in the different. The order was that respondent are directed to regularize the services initial with all consequential benefits. So that services, my lord. Services they were rendering. My lord, in the counter they admit what services were rendering. The lord, can you see their counters in the before the tribunal?
May I submit my lordship may straightway come to the page 227. The complaints have been filed by us before the tribunal.
I'm coming to that. I'm coming to that. Basing on that tribunal as well. My lord, may kindly see the page 92. But they have admitted in what capacity we are working. Page 92. 92, yes. Page, para 5. It is humbly submitted that applicant number 1, Subhankar Das, was engaged as teaching assistant oblique library insert with effect from 3795. Applicant number 2, Badrinath Jena, was engaged as technical assistant deferred from 1495. He is a graduate engineer. And applicant number 3, Jitendra Pati, was engaged as computer instructor oblique teacher with effect from 7/9/2002 in the national campus of INC in short-term contract basis. Their engagement is being extended from time to time, usually for the period ranging from 6 months to 1 year at a time. They have been designated as library coordinator, technical coordinator, and academic coordinator, respectively, with effect from 17/12/17 on consideration of the request without any change of that remuneration. So, can you see that order which they said that relevant compliance with the affidavit? Sorry, regularization order, my lord.
Complaints of 227.
No, 206. 207 your complaint. 206.
No, what affidavit filed? Lordship may give lordship.
Mr. Pari, please have patience. 206, yes. Well, they are for the 206, my lord. The 206, my lord. It is in respect of petition number 1. In implementation of the above order of the Honorable High Court of Orissa, is hereby appointed as multitask MTS in level 1 pay matrix of so until further order. The supernumerary post MTS created. MTS is the lowest rank, and that is no lowest rank that is in the group D, and group D, and also and they have promoted. And in respect of petition number 2 also.
There was no sanction post.
Can see petition number 2 is 208, my lord. Same multi-task. Well, if they admit that we have working as a technical coordinator, library coordinator, and the posts are there, my lord. The other cases, my lord, where they have referred to, and we have relied on which tribunal has passed order. They have been there adjusted against their post they are working, like clerk and other posts. What was your contention is that the very post which you are holding, yes, and once the direction was that it is to be regularized, yes, it doesn't mean that they will regularize in a lower post. In lower post, any post they like. Any post they like. That was a submission, and kindly see their bylaws, my lord. The MTS, their bylaws. 311 bylaw. Well, the 311 lots of kindly see the bylaw. The posts are there specified because the bylaw. Sorry, bylaws. Senior 8 your lordship will get senior librarian. Senior librarian, the library coordinator I was working. There is no senior librarian in that office. Then assistant manager technical. I have a person number 2 is a graduate engineer and he was a technical advisor. And person number 3. Post is technical assistant. That is different. So and your lordship person who was one Manoj Jena was regularly for the earlier. What about these posts? Multitask transfer किसी नहीं है. Absolutely, there is no such post like multitask transfer. How they said that that has been complied with the. I do not know. That is the basing on which now the tribunal has disposed of basing on their compliance affidavit. Where is that compliance affidavit? Compliance affidavit 227. 227. Doing it very seriously. 227. 227. 227 and
it is better, my lordship. Lordship may start reading from para C onwards.
para 227, para 3 election candidate. But the person who was getting much less salary than me, now he has been posted above me and given. In the pertinent
May I read para 3?
the petitioners, Mr. Subhankar Das, Badrinath Jana, and Jitendra Pati were engaged purely on contextual basis only to meet the extensive in Indian Institute of Mass Communication Deccan campus and not by following proper selection procedure, which is usually adopted by regular appointments. Further, contrary to the claims of the petitioners, the appointments are not made against sanction posts because they till date they were not sanction posts. And this once the order has been passed that to regularize means that services, services they are rendering. That is
There is no sanction post, nothing. Basing on order of the court,
to fill up the post. They have also filed in IA. Advertisement allotment and it's the IA. Like this. IA 22983. No allot ballot. They have advertisement. They have doing posters. Let's see. Mr. Pari,
yes, ma'am.
The sanction code, etc., you must have been taken the ground in the counter affidavit also before the.
Lordship, for a moment, Lordship, take the same paragraph 3.
Before this court when you filed the writ petition. So, in spite of that, the prayer has been allowed and your writ petition has been dismissed. So,
once again, I'm just clarifying. I'm just clarifying. Lordship, says same paragraph 3. Once again, I'm reading back.
Paragraph 3.
It is pertinent to mention that the petitioner, that is Mr. Such and such, 3 persons name, Sukant Das, Bandra Jana, and Jitendra Pani, were engaged purely on contractual basis only to meet the exigency of Indian Institute of Mass Communication and not by the following proper selection procedure, which is usually adopted by the regular appointment.
Mr. Pari, we just want to ask you, have you not taken this particular ground in your counter affidavit in the original application? Have you not taken this ground in your writ petition?
That I didn't examine because the first time it was computed there.
It is on record that they have filed, that is why.
Yes,
when you have taken those grounds, in spite of that relief has been granted, how can you post them in a post which is even non-existent like that? That is so that there is no such.
I before my lord in the twofold prayer, my lord. One submission, one is that this writ is not maintained because they by name they have filed. Even though a person was in contempt by name, according to Supreme Court judgment, what last occasion my lord, my learned senior has cited upon before the High Court. I have examined this. By name they cannot be. This department authority, because it should be final writ forum. That is I am analyzing, madam. That is I am analyzing. That read court cannot accept the person's name by name. It cannot be maintainable. Yes, read is maintainable, but not by name. What I am submitting, they are not in constant of they are treating the person by name.
All right, this petition has been filed by the petitioners challenging the order dated 26/9/2025 passed by the London Central Administrative Tribunal, Cuttack Bench, Cuttack, in CP number 260/00069 of 2024. And for a direction that to punish the opposite parties for committing the offense of contempt for deliberate, willful and intentional violation of the order dated 15/7/2023 passed by the London Tribunal in OA number 163 of 2018, which has been confirmed by this court by judgment dated 2/11/2023, passed in WPC number 34332 of 2023, with a further direction to the opposite parties to regularize the services of the petitioner from the initial date of their journey in the respective post. They have been working with all consequential service benefits. Mr. Mishra and Senior Advocate submits that the original application was filed by the petitioners before the Learned Tribunal with following reliefs. Quote the paragraph number 8 relief sought for, and that is there in page number 17 of the additional document at flag D. The opposite parties entered appearance in the original application, and wherein in paragraph number 5 specifically they have stated that the Subhankar Das Uji petitioner number kete? Petitioner number 1 was engaged as teaching assistant, public library in charge with effect from 3/7/1995. Our Badrinath Jena kete number? Petition number 2. Petition number 2. Badrinath Jena was engaged as technical assistant with effect from 1/4/1995. Jitendra Pati, number 3, and petition number 3 was engaged as computer instructor oblique teacher with effect from 1/7/2002. And they have been redesignated in Bhenkana campus of Swanso on short-term contract basis, and their engagement are extended from time to time. Stop. The Learned Counsel for the petitioner drew the attention of this court to the order dated 13/7/2023 passed by the Learned Central Administrative Tribunal while disposing of the ON number 163 of 2018. And the Learned Tribunal specifically came to hold as follows. Quote paragraph number 12 in its entirety, that is in page number 178 and 179. Mr. Mishra and Senior Advocate further submitted that the order dated 13/7/2023 passed by the Learned, aforesaid order passed by the dated Swanso, passed by the Learned Central Administrative Tribunal, was challenged before this court by the opposite parties in WPC number 34332 of 2023, and this court by judgment and order dated 2/11/2023 has been pleased to hold as follows. Quote paragraph number 9 and 10 in its entirety. The Learned Counsel submits that after passing of such order, the petitioners were engaged. कहीं से order टा कहीं? चलो ठीक जो were engaged. आपने CPR लिखी थी बताओ निश्चय. 206 minute. And this is 17/206. 206. अच्छा.
But we have taken that ground in its counter itself.
समझते तो सही multitasking for
Yes.
in multitasking staff bracket MTS in level 1 of
lowest level
which of pay matrix with effect from 3/7/1995. से 3 जन जगह से है ना? 3 जन से. According to Mr. Mishra, since the
out of 1/4/95 out of 6 years for a product.
some बुझ गए थे. 3 जन. The submits that the post in which they were all the 3 petitioners were regularized were at a lower rank, lowest rank, and therefore the petitioners filed the contempt petition before the London Central Administrative Tribunal, and the show cause was affidavit was filed on behalf of the opposite parties, and grounds have been taken mainly that say you
sale appointment was not in accordance with
227
para
227 para 3
सर ता पूर्वरु टिके हम काउंटर जा अछि इंटेंशन टा कंटेंशन टा लिखते भली जा
20
para 5 is compliance
227 जोटा
para 3 তারপরে para 5
227 para 3 para 5 but prior to that page 92 is relevant para 7 our counter file before the tribunal
227 paragraph number 3 and then 5 re likhi diyantu compliance of the order so and so
it is substantiate the counter affidavit
so cause the London Tribunal has been pleased to what order was passed in the ultimately by the tribunal
dismiss the order 262 minute
the London Tribunal found that since the opposite parties have complied the order, therefore the CP has no legs to stand and accordingly drop the swans. Mr. Mistral and senior advocate submits that the dropping of the contempt proceeding against the opposite parties suffers from total non-application of mind, in as much as the post in which the regularization was made was not the post in which the petitioners were holding, which would be evident from the counter affidavit filed by the opposite parties. Moreover, the stand which has been taken that the posts they were illegally
not regularly recorded and
that they were not those quote is a paragraph like
227 para 3 not against
the grounds which has been taken in the show cause that in order to meet the exigencies the appointment was made on contractual the engagement was made on contractual basis and not by following the proper selection procedure, and it was not against the sanction posts were also taken at the threshold, but that was torn down and the order was passed by the London Tribunal to regularize the petitioners, and therefore the regularization should have been in the letter and spirit of the order passed by the London Tribunal and not in any post the opposite party lied. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. Requisites for issuance of notice shall be filed by day after tomorrow by speed post with Swanshaw. Matter be listed Swanshaw. Yes.
Well, I filed to try. What happened? They are insisting on joining us, joining in their
such post is there. We don't have any post sanction post. We don't have a sanction post. Basically, the direction of the court to have complied.
Of this, they will join. Subject to the result of this, without prejudice to their right, they can join. Let them get the salaries.
Salary they are getting out as per the.
So without prejudice to their right and subject to result of this application right now, they can join.
That is your IN number 298.
21255. 212, that is 22983.
IN number so and so. This is an application for
22933 that they have issued advertisement to fill up the said post. That is why 22983 is that IN.
They will not have to join.
Posts are available and they have advertisement if they ultimately if Lordship will allow the
then the post will be filled up.
My lord may keep it to after vacation. We'll hear the matter.
229, that those IAS, my lord, will also keep pending. Yes, my lord. Only 22983 will also kindly see. I see 229. Let's see that they issued advertisement to fill up those posts. No, that is that filling of the post. If we say subject to the result of the so and so, that we can do.
No, nobody is destined to appear in the apply in the post.
No, but they are apprehensive of their right. They may lose their right of the post.
There is no sanction.
That is how. No, at best they can join subject to this.
No, that is
without prejudice to their right.
It is right that way. But so far as this IA is concerned, that they are going to fill up the post. That is the reason why it says that at least because one has already retired. Only 2 petitioners are left. Petitioner 1 and 2. 3 has already retired.
How many days are
retirement?
How many days are left for them?
Only for one is for 1 year so and so, and the other one is for
anyway, but they have
this advertisement when it was published about 12th of
the last date is
last date is 19 January 26. Last date 19 January 26. So you file it, we are fixing it prior to that.
Yes.
That would be better. Let's me issue notice on this. I hear a notice issue kar diyantu, accept one set of process fees kar diyantu, hai na. This matter be placed upon karo achi date of kebe last 19th one 19th one put a date fix up kar diyantu, hai na. Monday re fix up kar diyantu.
I have a small submission. Well, as regard to maintain with read person, I have raised the point that may be reflected in the order.
That has already been. We have held that it is maintainable.
That focus will be of no use right now.
Yes.
That is
but because it is a file, everybody's name. This is the whole problem.
Now they are to engage their personally some advocates. They may engage.
It is a read, my lord. I not contempt. They can engage, but it is a read.
Next.
You know, there.
Item 15.
Possibly. Item 15. Well, let's say 12 January. Possibly. 12 January, right? Yes, item number 15. Referred to in the para 5 of the counter. They have been redesignated. That party also kindly redesignated. Para 5 যেটা কইলে যে সেই যে পোস্টে কাম করে পরে যে redesignated ହେଇଛନ୍ତି সেটা এই সেদের কাউন্টারেশন
ମୁଁ ସେଇଟା କହିଲି consensual to our counter filed when paragraph 8
पूरा कोट कर देना सेटा 3 और 5 को पूरा कोट कर देना possibly yes काउंटर एफिडेविट पूरा कोट
ना এটা হচ্ছে শো করতে না এথরে এফিডেভিটটা আমি কাউন্টার এফিডেভিটটা হচ্ছে প্যারাগ্রাফ 8 পেজ 87
page 92
paragraph 3 and 5 no paragraph 3 ତାଙ୍କ
para 7
ଏଟା ହଉଛି ତାଙ୍କ କାଉଣ୍ଟରଟା ହଁ
para 7 ତ ହଉଛି ଆମର ସବ
ପୁରା 92
92 ର পেজ ପାରା 7 ମୁଁ କହୁଛି
entire
ଆମେ କଣ କାମ କରୁଥିଲୁ paragraph 5 କୁ ଆପଣ କହୁଛନ୍ତି କୋଟ କରିବ अच्छा ମୁଁ ଯୋଉ ଡାକିଲି ନା ସେମାନେ ଏଇ ପୋଷ୍ଟ ରେ ଥିଲେ ବୋଲି ସେ ପୁରା ଫାଇଲଟା ପୁରା କୋଟ କରୁଛନ୍ତି ହେଲା ପେଜ 92 ରେ ଅଛି ରିଟ୍ ପିଟିସନ ନା ହେଲା ହଁ ଖାଲି ମୁଁ ଗୋଟେ
counter part to that we have mentioned in paragraph 7 of our counter.
Yes. Possibly. Yes, item number 15. Yeah.
In this retribution, Your Lordship has filed challenging the order of Learned Central Administrative Tribunal under Annexure 1 at page 19. Your Lordship may kindly have a glance at page 19, Your Lordship.
Page 19.
Yes, Your Lordship.
19
Order.
First title.
What is that?
What you are challenging? What is your prayer?
Order at Annexure 1, Your Lordship. Dated 20th March 2025.
Yes, that has started since from 19, para 19.
The running page 27, Your Lordship. Sorry, Your Lordship.
Your prayer was to was annexure A by 1.
Yes,
that is the copy of the original application.
Yes,
relief sought for the page number 59. First prayer is to quash annexure A by 1. Second prayer is to hold that the initiation of the disciplinary proceeding and framing of the charge sheet against the applicant who acted as a quasi-judicial authority under section 7A of EPF Act 52 as bad in law.
Yes,
So
sir.
these were your pairs, and
What the learned Central Administrative Tribunal has held is at page 35, Your Lordship. The last 3 lines, Your Lordship, below last 3 lines. It has been held that.
Read the entire page, entire paragraph you read, paragraph 8.
Yes, Your Lordship. The aforesaid decision in the case of Swapan Kumar Bankura, Supra, has also been upheld by the Honorable Apex Court by order dated 8 January 2016 in special leave to appeal number so and so. We are reminded by the decision of the Honorable Apex Court in the case of Union of India versus Kunni Setti Satyanarayan 2006-12 SCC 28. In the said case, while allowing appeal, the Honorable Supreme Court considered the issue whether in writ petition quashing of charge sheet or show cause notice is a discretionary remedy, and if so, whether such discretion should not ordinarily be exercised by quashing a show cause notice or charge sheet, as the same doesn't infringe the right of anyone, but held that in some very rare and exceptional cases, the High Court can quash a charge sheet or show cause notice if it is found to be wholly without jurisdiction or for some other reason if it is wholly illegal. Also, in the case of State of Punjab versus V.K. Khanna and others, AIR 2001 SC 343, it has been held that while it is true that justifiability of the charges at the stage of initiating a disciplinary proceeding cannot possibly be delved into by any court pending inquiry, but it is equally well settled that in the event there is an element of malice or malafide motive involved in the matter of issue of a charge sheet, or the concerned authority is so biased that the inquiry would be a mere farcical show, and the conclusions are well known, then and in that event, law courts are otherwise justified in interfering at the earliest stage so as to avoid the harassment and humiliation of a public official. Thus, in view of the facts, statutory provisions, and law discussed above, we are of the considered opinion that the charge sheet dated 21st March 2017 is not sustainable in the eyes of law, and the same is liable to be quashed and is accordingly quashed. However, Your Lordship, the order doesn't speak about the maliceness involved in this case in the order of initiating departmental proceedings. Hence, the order of learned cat quashing the departmental proceedings initiated by a competent authority at its threshold is illegal. Moreover, by initiation of departmental proceeding, there shall be no prejudice to the delinquent. In my ground, also at page 14, Your Lordship may kindly have a glance at page 14, Your Lordship, the grounds. May I read, Your Lordship?
What is the allegation against him?
Maliceness, Your Lordship.
Malice is the allegation, but in passing an order in 7B of the EPF Act.
7A, Your Lordship, they just violate the, they just left the persons, all the employees are calculated in their computation. They have included in their, the enforcement officer have already mentioned all the employees, but they left the major person and mere trainees are included in that computation. So the rest are left from the getting benefit.
Oh, they have not been included.
Yes, yes.
Within the
major category are left.
So 7A is a proceeding for bringing the establishment within the ambit of the EPF Act.
Yes, sir.
So during the inquiry, 7A proceeding, he has left out some people.
Major employees are left. In that way, they benefited by the employer is benefited. May I read, Your Lordship, the grounds at page 14?
Page 14.
Yes, Your Lordship. There is a decision of Honorable Apex Court.
Wait. Yes.
In Government of Andhra Pradesh and others versus Appala Swami 2007 14 SCC 49. It is submitted further in the case of Union of India and others versus A.N. Saxena, civil appeal number 5051 of 1992. Honorable Apex Court by the order dated 27th March 1992 has observed, in the first place, cannot but confess out astonishment at the impugned order passed by the tribunal. In a case like this, the tribunal, we feel, should have been careful before granting stay in a disciplinary proceeding at an interlocutory stage. The imputations made against the respondent were extremely serious, and the facts alleged, if proved, would have established misconduct and misbehavior. It is surprising that without even the counter being filed at an interim stage, the tribunal, without giving any reasons and without apparently considering whether the memorandum of charges deserved to be inquired into or not, granted a stay of disciplinary proceedings as it has done. If the disciplinary proceedings in such serious matters are stayed so lightly as the tribunal appears to have done, it would be extremely difficult to bring any wrongdoer to book. We have therefore no hesitation in setting aside the impugned order of the tribunal, and we direct that the disciplinary proceedings against the respondent in terms of the charge sheet dated 13th 1989 shall be dated March 13, 1989 shall be proceeded with according to law. In fact, we would suggest that disciplinary proceedings should be proceeded with as early as possible and with utmost zeal. It was urged before us by learned counsel for the respondent that as the respondent was performing judicial or quasi-judicial functions in making the assessment orders in question, even if his actions were wrong, then could be corrected in an appeal or in revision, and no disciplinary proceedings could be taken regarding such actions. In our view, an argument that no disciplinary action can be taken in regard to action taken or purported to be done in the course of judicial or quasi-judicial proceedings is not correct. It is true that when an officer is performing judicial or quasi-judicial functions, disciplinary proceedings regarding any of his actions in the course of such proceedings should be taken only after great caution and a close scrutiny of his actions, and only if the circumstances so warrant. The initiation of such proceedings, it is true, is likely to shake the confidence of the public in the officer concerned, and also, if lightly taken, likely to undermine his independence. Hence, the need for extreme care and caution before initiation of disciplinary proceedings against an officer performing judicial or quasi-judicial functions in respect of his actions in the discharge or purported to discharge his functions. But it is not as if such action cannot be taken at all, where the actions of such an officer indicate culpability, namely a desire to mobilize himself or unduly favor one of the parties or an improper motive. There is no reason why disciplinary action should not be taken. Therefore, in the present case, Your Lordship, the learned Central Administrative Tribunal, instead of passing the charge sheet, initiating disciplinary inquiry, would have passed an order for early disposal of the whole.
This writ petition has been filed by the petitioner, Chairman, Central Board of Trustees, challenging the order dated 23/2025 passed by the London Central Administrative Tribunal, Cuttack Bench, Cuttack, in OA number 260/00639 of 2017. It seems that the opposite party, number one, Pradeep Kumar Mishra, filed the aforesaid OA, wherein prayer was made inter alia to quash the initiation of the disciplinary proceeding and the framing of charge sheet against him, who acted as a quasi-judicial authority under Section 7A of the PF Act 1952. The petitioner filed the counter affidavit and after hearing the parties and going through the pleadings, the Learned Tribunal has been pleased to hold that the charge sheet dated 21/3/2017 is not sustainable in the eyes of law, and the same is liable to be quashed and accordingly quash the same. You are Kalpita Gannayak, Land Counsel appearing for the petitioner, submitted that in view of the settled position of law as laid down by the Honorable Supreme Court in the case of Government of Andhra Pradesh and others versus B. Appala Swamy, reported in 2007, 14 SCC 49. In extremely serious matters where there is allegation of misconduct and misbehavior, the tribunal should not stay the proceedings.
This is the judicial proceeding. This is a judicial proceeding.
It was further held that need for extreme care and caution before the initiation of disciplinary proceeding against an officer performing judicial or quasi-judicial function in respect of his action in the discharge or purported to discharge his functions. Where the actions of such an officer indicate culpability, namely a desire to oblige himself or unduly favor one of the parties or an improper motive, there is no reason why disciplinary action should not be taken. The Land Counsel for the petitioner submitted that in view of the charges mentioned as per the charges in the charge sheet, since the allegations are very serious in nature and it appears that the opposite parties has what is your contention? It has shown the unduly favor.
Yes, sir, Lord.
Has shown unduly favor to some of the parties, no, one of the parties, to the establishment. Therefore, there was the quashing of the disciplinary proceeding by the Central Administrative Tribunal is not justified. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. Notice shall not be issued to opposite party. Number 2, requisites for filing issuance of notice shall be filed by day after tomorrow. Matter be listed after 2 weeks. Counter affidavit, if any, be filed in the meantime. Yes.
Item 16.
But in the prayer position, some typical error is there, so I want to correct the prayer.
The learned counsel for the petitioner submitted that since there are typographical errors in the writ petition, he wants to file an prayer portion. In the prayer portion, he intends to file an interim application for amendment of the prayer portion.
Yes.
And for such purpose, some time may be granted. List this matter after ensuing winter holidays. If any interim application for amendment is filed, the same shall be placed on the record. Okay. Upon petition achievement. After lunch now.
Item 25.
That legal. They you also can you convey time to place this matter. At way you also can take after vacation you also there is a delay 130 days.
You say life imprisonment.
Yes, yes,
Huh?
yes.
delay of time campaign होते
Some time ଦଉଛି preposition ପକେଇଲା ଟିକେ collect
ପରେ ଭିତରେ delay nomination ହଉ
IA ତ ଆଉ କିଛି ନାହିଁ. Only IA is for delay.
Yes.
conviction na acquittal
Oh, appeal against acquittal.
it has to
Oh,
acha this who is this appellant
ଟିକେ ଫାଇଲ ଟା ମୁଁ ଦେଖିପାରିନି ରାତିରେ କାଲି
appellant କଣ informant ନା କିଏ
ଫାଇଲ ଟା ଆଜି ସକାଳେ
informant ହଉଛି ତ୍ରିନାଥ ପ୍ରଧାନ state of Odisha
oh,
ଜଣେ
it is on behalf of informant.
acha IN number 2714 of 2025 this is an application for donation of delay. The stamp reporter has pointed out that there is delay of 140 days in filing this appeal. Issue notice on the question of limitation. Requisites for issuance of notice on opposite the respondent number 2 shall be filed by day after tomorrow. Matter be listed. You will commencing from briefing of for a popular objection, if any, to the delay condonation application shall be filed in the
yes.
Item 26.
The continuation of delay matter arrive for life matter under section 302 of this matter. Is the proof treatment for life?
IU number so and so, there is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 84 days in filing the criminal appeal. After going through the averments taken in claim of petition, hearing the land council for the respective parties, and since the appellant has been sentenced to imprisonment for life, we are inclined to condemn the delay. Accordingly, delay is condemned. I here disposed of and call for the trial court record. Interim application for bail and stay relation of time consider after receipt of the trial court record. In the meantime, the land counsel for the appellant shall supply the
deposition copies I have with me. Deposition copies are not with me.
When the trial court record will come, you take the and cover. Supply this one, sir. Yes, next.
Item 27.
It's a regular appeal. How did you prepare the grounds? That asking you. It's a regular appeal under section 302 IPC. Without seeing the deposition, you have prepared the ground and filed.
Deposition thila seta mu pen drive re dekhi deyଥିଲି ତାଙ୍କୁ ଆଣିକି.
All right, Arjun. Yes, next.
Item 27.
2/34. Right. Say all of the relate on person admit for them. There is interim application for bail and stay. Same identical. Next.
Item 28.
Item 28, my lord, I have already appeared in this case for appellant and my power is already filed by court. And this case is ready for hearing. As per direction of this honorable court, I have already filed my now.
The wakalatnama filed by Mr. Malay Kumar Swain is accepted. You have received the copy of the paper book?
My lord, already.
He submits that he has received the paper book. And have you received the paper? Grand counsel for the state also submit that he has received the paper book. This might be added to the hearing list in the second week of January. Yes.
Item 29.
Yes.
Yeah, in terms of order that is being granted.
Let me that will be filed by DGP personally as to what steps have been taken, not only.
Yes, you Jamujari
We captured in the mail.
ଆନରେ କଣ କରିଛନ୍ତି ଷ୍ଟେପ୍ ହଉଛି ଇଏ କେବେଠୁ ଖସିଲାଣି 2018 ଇଏ କୋଉଠିଆ ଲୋକ ମାନେ ହଁ ଲୋକ କୋଉଠିକାର ବରଗଡ଼ କଣ ଷ୍ଟେପ୍ ନେଇଛନ୍ତି let us see
kept their own chain. So who directs on that?
So our order was not only for recapturing this particular appellant, but we have stated that what steps have been taken not only in this case, but also in other cases where the life convicts have escaped, public absconded from so and so, to recapture them. And all the details in each case should be given serially, and it should be also be indicated if any action has been taken against the official who might be negligent or responsible for which the life convicts have been escaped. ସେଥିପାଇଁ କଣ କହିଲେ ଆପଣ? କିଛି ନାହିଁ. There is nothing.
There is a regular disease not is out of station because of national.
All right, we are noting it. That part is concerned. You ଆପଣ each କରିବେ ଏଇ ଲୋକଟା ଏଠି ଥିଲା ଏବେ ଖସିଲା ସେ ବା ଇଏ ଯାଇଥିଲା ଫୋରଲୋଗ ରେ ଆସିକିନି କରିନି ତେଣୁ
data of individual
personal liability kaha samane
order is very clear that all the details in each case should be given serially and it should be indicated if any action has been taken against any official. ଆପଣ ଦେଖନ୍ତୁ ଏଇ କେସ୍ ରେ ଏ ଲୋକ 2018 ରୁ ଗଲାଣି ଆପଣ FIR ହେଇକିନି ଚାର୍ଜସିଟ୍ ହେଇକିନି ୱାରେଣ୍ଟ ହେଲାଣି ସେ ଲୋକ ଗାଁରେ ଅଛି ଏବଂ ଏଇ ହେଲା ପରେ ଏବେ 13/12/2025 ରେ କ୍ୟାପଚର ହେଲା.
Fact remain with as will not say but fact remain that the jail authority immediately regularly contacted with the local police and the regular. They are not in this respect. The jailer in the present case has moved there. One of the friend is Bargot. Then after he traced out, intimated. Till then did not cooperate. Then I have called to the DCP concern. Thereafter these things has happened. The regular police also not cooperating. Not even registered the FIR. In some time furlough cases, some cases.
ଏଇଟା ତ ରେଜିଷ୍ଟର ହେଇଯାଇଛି.
ନାଇଁ ରେଜିଷ୍ଟର ହେଇଗଲା ସେମାନେ ଦେଇଦେଲେ କିଛି
ଏଇଟାରେ 19 ତାରିଖରେ ଫସିଲା 21 ତାରିଖରେ ଆପଣଙ୍କର କେସ୍ ରେଜିଷ୍ଟର ହେଇଛି 2018 ରେ ତାପରେ ଚାର୍ଜସିଟ୍ ହେଇଯାଇଛି କିନ୍ତୁ ଲୋକ ଅଛି ଆଭେଲେବୁଲ ଅଛି ଆପଣ in spite of issuance of warrant ବି ଆପଣ କହୁଛନ୍ତି NBW ଇସ୍ୟୁ ହେଇଛି JMFCO ଭୁବନେଶ୍ୱରରୁ.
The superintendent jail, if found that the concerned police did not cooperate, what step did jail superintendent take? He is to take up with his higher officer or not? He will simply sit over it.
No, in this case, he has take up the higher authority, DCP and commissioner. Thereafter, things are.
କିଛି ଲେଖିନାହାନ୍ତି ନା ଆପଣ?
ଏଠି ତ କିଛି ନାହିଁ. How can you say?
ସେଇଥିପାଇଁ ଆମେ କହିଥିଲୁ erring officials କିଏ? It may be the person who has not executed that NBW. It may be that registration ଆପଣ ଯଦି କହିଲେ registration କରୁନାହାନ୍ତି ବୋଲି, then what action you have taken?
Then a detailed affidavit record is filed by the regular DCP.
ଲେଖନ୍ତୁ. In terms of the order dated 10/12/2025, an affidavit has been filed by Sri Amitabh Thakur, Additional Director General of Prisons and Correctional Services, Odisha, wherein he has stated that though the Director General of Prisons was supposed to file the affidavit, but as per the order of this court, but he's absent in the headquarters for his official tour. For as per the direction and authorization of DG of Prisons, this affidavit has been filed. It is further stated that from Biju Patnaik Open Air Ashram Jamujhari, altogether 17 live convicts have escaped at different times, and 15 live convicts were released either on parole or parole have not yet reported back. So far as the appellant Munshi Bhue alias Mansi Bhue is concerned, he had escaped from Biju Patnaik Open Air Ashram Jamujhari since 19/6/2018. Stop. The superintendent lodged the FIR before IIC Chamdaka Police Station, which was registered as Chamdaka PS case number 90 of 2018, dated 21/6/2018, and on completion of investigation, charge sheet has been submitted against the appellant under section 224 of the Indian Penal Code on 27/8/2025, and thereafter warrant has been issued by the London JMFC O Bhubaneswar against the appellant on 28/8/2025. Stop. After issuance of NBW, the local police of Bhatli in the district of Bargarh was informed by the superintendent of Biju Patnaik Open Air Ashram and as the petitioner, as the appellant belonged to, was residing in under the jurisdiction of appellant's house was under the jurisdiction of the said police station, and information was received from the reliable source that the appellant was staying in his village Tejagor with his family members. Accordingly, the appellant was recaptured on 13/12/2025 and remanded to special jail, Neshur. Stop. The affidavit is taken on record. Stop. So far, in the order dated 10/12/2025, we have also indicated that the DG of Prisons should file an affidavit wherein he has to indicate the steps taken in other cases also where the live convicts had escaped, absconded from Biju Patnaik Open Air Ashram Jamujari to recapture them. And all the details in each case should be given serially, and it should be also indicated if any action has been taken against any official who might be negligent or responsible, for which the live convicts have escaped oblique absconded. Though a vague averment has been taken in the affidavit that in some cases of escape and non-return from in paragraph number 11 of the affidavit, it is stated that in some cases of escape and also non-return from the furlough oblique parole, no FIR was registered. And after the order of this court, as per the direction of DG, FIRs in all the cases have been registered. And the matter has been taken up with police and jail authorities of the concerned district for apprehending the escapees at an earliest. Stop. We are not satisfied with the affidavit so far as the steps taken in other cases. Therefore, as we have indicated we have mentioned that the details of each case has to be given serially in the affidavit. Therefore, the DG of Prisons shall file a fresh affidavit indicating therein the steps taken against the against the live convicts who had escaped oblique absconded from Biju Patnaik Open Air Ashram Jamujari, so also against the officers who might be negligent or responsible in such escape, oblique absconding. Stop. The matter will be listed in the third week of January 2026. The affidavit shall be filed in the meantime. After going through the affidavit, it really surprises us that when the appellant escaped since 2018, and Chandaka PS case was registered on 21/6/2018. Why so much of time was taken for completion of investigation and submission of charge against the appellant, only which was submitted on 27/8/2025. And if the warrant of arrest was issued by the JMFCO Bhubaneswar on 28/8/2025, and the appellant was staying in his village, Tejogolo, with his family members, why the warrant could not be executed earlier, and the appellant was only recaptured on 13/12/2025. This shows that even after a live convict has escaped from the open air ashram Jamujari, the matter has not been taken seriously by the concerned authorities in recapturing him. it is expected that in all other cases where similar thing has happened, the concerned authorities should rise up to the occasion and do the needful in taking appropriate steps in recapturing such live convicts. A free copy of the order be handed over to the Land Council for the state. Yes, next.
Item 30.
Yes, madam.
We have sent the letter for address verification because it is out of state. And so also we have received the document of the local dweller. We may allow some time to verify this.
No, we have mentioned there that the superintendent of police Kemujer has to make necessary correspondence with the counterpart.
That has made, but we have not obtained.
Huh?
That has made, we have not obtained that confirmation.
So the you are to obtain instruction whether the SP has made the correspondence or not. And we have supplied you the free copy of the order.
That has
Have you sent it to the concerned SP?
Yes. A local shield verification, we have received the document. We may have some more time to verify.
No, you should have produced at least the letter which has been written or the communication which has been made by the SP Kemujer to his counterpart in that West Singhbhum. Are you having that letter?
I mean, order sheet you communicated to IAC that and to.
That is your communication to the SP. Your direction was to the SP.
The direction was to the SP. Have you written any made any comment? Then
no, then
why?
The order of the copy of order was also applied.
The order has come.
This was
maybe
the London Council for the State submits that even though he has received the copy of the order dated 28/11/2025, in which there was a specific mention that the Superintendent of Police Kemujer shall make necessary correspondence with the counterpart of the West Singhbhum to verify the correctness of the address of the appellant given in the cause title, but the communication has not yet been made to the Superintendent of Kemujer, but instead it has been made to IAC of
Naya Court.
Huh?
Naya Court.
Ragudia.
Kemujer.
Naya Court.
Naya Court. देखो ठीक से.
Naya Court to that. Kemujer district IAC Naya Court.
Naya Court police station. However, it is submitted that during course of the day, necessary communication shall be made to the concerned Superintendent of Police and follow-up action taken by the SP Kemujer shall be apprised to this court on the next date. List this matter in second week of Swansea. Free copy of the order be handed over to the land. Yeah.
Item 31.
Two appellants are there. Appellant in custody for more than 17 years. About 18 years custody certificate was also called for. Of course, it's a triple murder case. And case rests on the single witness knowledge who has examined after 4 months of the occurrence.
No. How many appellants are there?
Two appellants. One I'm appearing for appellant number 1, and my friend he's appearing for appellant number 2. Except some interim
No, earlier your bail application.
Yes, rejected.
Listed on 3/4/2014 rejected. 14/11/17 rejected. 29/24 also rejected. Twice it has been rejected. The only main thing is that your period of detention.
The detention.
But on the other hand, it is a case of triple murder.
Triple murder.
And there is direct evidence.
Well, it's only one witness was examined after 4 months.
That is
Definitely.
You get ready. The case paper book is there.
Paper.
You are not received the paper.
Yes, I have received the paper.
Get ready. We are taking up this matter out.
Let them release for some days.
They are not rejecting it, but keeping it pending. Since it's a case of triple murder and on a number of occasions, the bail application of the appellants have been rejected. List this matter, and the paper book has been prepared. List this matter in the second week of January 2026. The Land Council for the appellants submit that he has received the paper book. They have received the paper. So also the Land Council for the state.
Conduct was also called for everything. Let them do.
Second week. Next.
Item 32.
Every time it was listed for hearing, but it is not taken up.
Next, item number 32.
My lord, the appellant is in custody, my lord, since 6/4/2015. Your lordship has called for custody, that is 11 years, 6 months, my lord has got, and there is also an instruction to
How
get.
many times your bail application was rejected?
No, madam. Previously, there was a difference of opinion. So that previous order, your lordship has said that that was not pressed, and this is a
difference of opinion.
Difference of
Divergent
opinion.
Between the honorable judges.
My lord, that your lordship has already clarified. So it was not pressed, and this is the.
When it came to the third judge, it was not pressed.
My lord.
Then you have filed this appeal.
My lord. The lordship has called for the custody and behavior in the jail.
No, earlier it has not been rejected. Who is your affiliate?
Lakshman Mahanta, sole appellant.
We are not.
তারপরে আউট আসছে না অর্ডার ডেট করেছি 29/2023 অর্ডার নম্বর হচ্ছে 15। कस्टडी सर्टिफिकेट के वे
कस्टडीটা আসছে জেল কন্ডাক্ট এন্ড ক্রিমিনাল অ্যাক্টিভিটি
কস্টডি আসছে না কত দেয়া হয়েছে আজ্ঞা 4 to 45 days 4000
वर्ष 6 मास লেখাই
আজ্ঞা
এটা সিঙ্গেল মর্ডার কেস
ইয়েস অলসো
সিঙ্গেল মর্ডার তো ব্যক্তি কমপ্লিট করিব না ঠিক For the state, the land council from the custody certificate, it appears that the petitioner is in judicial custody for more than 11 years and 6 months. As for the previous order, the land council for the state has produced
Jail conduct and criminal
produced the report from the IAC Sukinda police station to show that there is no criminal antecedent against the petitioner. He has also produced the report from the Special Sub-Jail Jajpur Road, which shows that the conduct of the appellant was satisfactory. The reports produced by the land council for this are taken on that one. The land council for the state number submitted that the bail application of the petitioner was rejected on merits by order dated 21/7/2015. Considering the submission made by the land council for the respective parties in view of the available materials on record, while not inclining to release the petitioner on bail on merit, but taking into account his period of detention in judicial custody and absence of any chance of early hearing, and keeping in view the leti one, so we are inclining to release him on interim bail for a period of 3 months. Yes. Date fix of further, we will file this surrender certificate. Inimas interim bail. Yes, next.
Item 33.
Wait, please allow. The appellant has been convicted under section 498, 304B and 302 of IPC and sentenced to imprisonment for life. I believe your lordship had granted interim bail for 3 months. And I have next the surrender certificate along with the IMR.
What is the conduct?
That we have.
You have not listen, IN number so and so for bail. And the land council for the petitioner submit that as for the order dated 14/5/2025, after availing the interim bail period by 3 months, the petitioner has surrendered before the Law and Trial Court, and he has also filed the surrender certificate with the interim application. Council for the state seeks for an urgent instruction on the conduct of the petitioner while now interim bail. 2nd week of January 2026. Yes.
Item 34.
Item 34, let me have directed to file the conduct certificate while an interim bail.
Which was incentive of life.
So you are granted interim bail
Yes, ma'am.
by the order dated 27/11/24.
Yes, ma'am.
For a period of 3 months.
Yes, ma'am.
And you did not surrender in time.
No, ma'am, yes, surrender.
No.
Surrender certificate.
No, surrender, but not on the date.
Yes.
That you in our order dated 5/4/25, you have stated that after availing the interim bail period of 3 months, the petitioner has not surrendered before the land. It is your submissions. That is why we called for a report from the land and trial court.
My associate has appeared here, could not follow the order.
Could not follow.
But କିନ୍ତୁ ସରେଣ୍ଡର କରିଛି as per instruction ସେ ସରେଣ୍ଡର କରିଛି ରାଇଟ୍ ଟାଇମରେ ମୁଁ ସରେଣ୍ଡର ସାର୍ଟିଫିକେଟ ବି ଦେଇଛି ମାନେ ଲର୍ଡସିପ ଭାଇଟ୍ ଅର୍ଡର ଡେଟେଡ ୟୁ ଲର୍ଡସିପ 3/3/2025 ମାନେ as per the direction of the honorable high court IA number so and so the convict surrender before the court will after expiry of the interim bail of 3 months being identified by the council of taken to the judicial custody. And it has already filed another also there, my lord. So you got full not follow that's why my lord will lordship call for report, my lord. And also for another period of 3 weeks for death of his father who was also surrendered. My lord.
ଏବେ ସରେଣ୍ଡର କଲେ
ମାନେ on 3/3/2025
କାଇଁ ସରେଣ୍ଡର ସାର୍ଟିଫିକେଟ କାଇଁ
କମ ସେ କମ ଦେଇଥିଲୁ କଥା ଫାଇଲ କରିଦେଇଥିଲି
କେବେ ଯାଇଥିଲା ଆପଣ ବେଲ୍ ଦିଆଯାଇଥିଲା
ବେଲ୍ ଲର୍ଡସିପ has granted on my lord
27/11/2024 ଆପଣ ବୋଲେ 3/3/2025 ହେଇଥିବ ସେ ଆପଣ ସେ କିଏ କଣ ଆସୋସିଏଟ ବୁଝିପାରିଲେନି
ସେ ଜାଣିପାରିଲେନି ସେ ଛିଡା ହେଇଗଲେ ସେ ଜାଣିପାରିଲେ
but you had filed an application for extension of the interim bail
ସେଇଟା ନୋଟିସ୍ ବି ତାଙ୍କୁ କହିଥିଲି କରିବାକୁ ଆଉ ସରେଣ୍ଡର ସାର୍ଟିଫିକେଟ ସେ ବୁଝିପାରିଲେନି ସେ ସେଇଟା ନୋଟିସ୍ କରିବାକୁ ବି କହିଥିଲେ
ନାଇଁ ସିଏ ତ ନୋଟିସ୍ ହେଇଗଲା ତେଣୁ ବୋଧେ ଆପଣ ସରେଣ୍ଡର ନ କଲେ ବୋଲି এটা ফাইল করছিল এক্সটেনশন করিয়া
সেটা তা পূର୍ବରୁ କରିଥିଲି ବଟ୍ দ্যাଟ୍ ୱାଜ୍ ନଟ୍ କେସ୍ ଆଗେ ମୁଁ ସରେଣ୍ଡର କରିଛି ଟାଇମଲି ସେ ବୁଝିପାରିନଥିଲି ସେଥିପାଇଁ ରିପୋର୍ଟ ବି ଆଗରୁ କରିଥିଲି
So on merit, we have rejected your bail application, but you are in custody from
22/12/2015 ମାନେ ଇଣ୍ଟରିମ୍ ବେଲ୍ ଆଉ ଥରେ 3 ସପ୍ତାହ ପାଇଁ ଯାଇଥିଲା ଫାର୍ଦର ଇଏରେ ସେ ବି ସରେଣ୍ଡର କରିଥିଲେ ରାଇଟ୍ ଟାଇମ୍ ପ୍ରିଭିୟସଲି ବି ଯାଇଥିଲି
ସେଇଥିପାଇଁ କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ କେମିତି ଦେଖୁଛି 5 ବର୍ଷ
ଲର୍ଡସିପ ଭାଇ ଆମର 8 years ଦେଖିଥିଲେ ସେଇଥିରେ ଆସିଥିଲା ଯୋଉ
ବାଇଫର୍କେଟ ହେଇଥିଲା ନାଇଁ 5 years 6 months 1 day
8 years ହେଇଥିଲା ଲର୍ଡସିପ ଭାଇ ଗ୍ରାଣ୍ଟେଡ ଇଣ୍ଟରିମ୍ ବେଲ୍
କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ ଯାହା ଅଛି କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ ରେ ଦେଖଉଛି ଯେ 22/12/2015 କଷ୍ଟଡି ଗଲେ ଆଉ 14/4/21 ପର୍ଯ୍ୟନ୍ତ obviously that is the order of pronouncement of the judgment এটা হলো 5 ବର୍ଷ 3 ମାସ ତାପରେ 15/4/2021 ରୁ 23 ପର୍ଯ୍ୟନ୍ତ ହେଲା 8 ଦିନ ତାପରେ ଆଉ କିଛି ଲେଖା ହେଇନି ହଁ ତାପରେ actual custody period after conviction 2 ମାସ 8 ଦିନ ଲେଖା ହେଇଛି 21 ରେ ବୋଧେ ସେ ଯୋଉ कोरोना period रे बोधे अपन पढ़िछन तेणु you are not there in custody so that is how the report has come the report
there is a report custody certificate in the 8 ବର୍ଷ ଦେଖଉଛି।
8 ବର୍ଷ 10 ମାସ।
8 ବର୍ଷ
He was released on 14/4/2021 and again released on 9/12/23.
କୋଉଠି ଆଉ ଗୋଟେ
ଦିଟା
ରିପୋର୍ଟ ଅଛି?
ଦିଟା କଷ୍ଟଡି
ଦିଟା ରିପୋର୍ଟଟା କାହିଁ ଏଇଠି ରିପୋର୍ଟଟା
ଫାଷ୍ଟ କଷ୍ଟଡି
First custody ରେ
8 ବର୍ଷ
Page 100, 185.
ଫାଷ୍ଟ କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ ଆଟ୍ ପେଜ 185 ଏଟା ଦେଖୁଛି 8 ବର୍ଷ 10 ମାସ 14 ଦିନ।
ସେଇଟା ଆମେ ବୋଧେ ରିଫ୍ଲେକ୍ଟ କରିଦେଇଛୁ
That is of 11 that November 2024.
ଏଠି ଲେଖା ହେଇଛି ପିରିୟଡ଼ ଅଣ୍ଡରଗୋନ୍ ଆଜ୍ ଫଣ୍ଡି 15/4/2021 ରିଲିଜ ହେଇଛି 9/12/2023 ସେଠି ଗୋଟେ ହେଇକି ତାପରେ ବି
ଆଉ ଥରେ
31/12 ପୁଣି ପଶିଲା 326 ଦିନ ଏମିତି କରିକି ସେ ଦେଖୁଛନ୍ତି 8 ବର୍ଷ 10 ମାସ 14 ଦିନ। 8 ବର୍ଷ 10 ମାସ 14 ଦିନ ମାନେ ବର୍ତ୍ତମାନ
ହେଲା
ଏଟା 11 ନଭେମ୍ବର 2024
31/12/23 ହେଲା ତ 15/8 ବର୍ଷ ହବ 10 ମାସ ଯଦି ଆମେ ଧରିବା ଫାର୍ଷ୍ଟ ଆଡମିସନ ଡେଟ୍ 22/12/15 ମାନେ ଡିସେମ୍ବର 15 ଆଉ ଡିସେମ୍ବର 23 ହେଲା 8 ବର୍ଷ ହେଲା
ଡିସେମ୍ବର 23
ହେଲା 8 ବର୍ଷ 15/8
ତାପରେ ପୁଣି
ଆଉ 10 ମାସ ପୁଣି କୋଉଠି
31/12/2023
ତାପରେ ଡେଟ୍ ଅଫ ଇଏ
ପୁଣି ପଶି ପୁଣି ପାଖାପାଖି 326 ଦିନ ଅଛି ଏଇଟା 326 ଦିନ ତେଣୁ ସେଇଥିପାଇଁ ଟୋଟାଲ ପିରିୟଡ଼ ଦେଖୁଛି 1281 ଦିନ ସେପ୍ଟେମ୍ବର ତାପରେ ଏଇଟା ହଉଛି ଆର ହଉଛି 1913 ପ୍ଲସ୍ 1281 ମିଶେଇଛନ୍ତି କରିଛନ୍ତି 31
ସବସିକ୍ୱେଣ୍ଟ କଣ ଏମିତି ଆସିଗଲା
ସେଇଟା ଗୋଟେ କଣ ବିମଳ କୁମାର ମିଶ୍ର
ନାଇଁ ଏଇଟା ଅନ୍ୟଟା ଏଇଟା ତାରିଣୀ ସେନ ଦେବରୀ
କୋଉଟା
ସେକେଣ୍ଡ ଟା ଏଇଟା ତାରିଣୀ ସେନ ଦେବରୀ ଇଜ ଦି ସୁପରିଟେଣ୍ଡେଣ୍ଟ ଅଫ
ନାଇଁ ସେଟା ବି ସେ ବିମଳ ଯେ ସେଇଟା ଆଉ ଦେଖିନି
ସେଟା ତାହେଲେ ଦେଖି ପିରିୟଡ଼ ତ ନେଇଛି from 22/12/15 to 14/4/21 15/4/21 to 23 এটা ଗୋଟେ ପୋର୍ସନ ଦେଖେ
ये लोक ना विमल कुमार मिश्र तो अच्छा दीटा रिपोर्ट होची विमल कुमार मिश्र रो आ गोटे ऑप्शन है जहाँ देखो सीनियर सुपरिटेंडेंट सर्कल जेल बरहमपुर आ गोटे है जेल सुपरिटेंडेंट कुदला ओडिशा तेणु कोटारे से ठीक
एफआईआर नंबर सब ठीक अछि त
एफआईआर मालट
एफआईआर टा कोठी गोटे एफआईआर होची 12 रो 2012
हॉलीवुड पीएस केस नो 38/12 12
There are both APR same.
both are 38
Same APR.
And your lordship file granted interval that has been reflected as per custody certificate.
हमें कौन रिफ्लेक्ट करछु ये ना दीटा कस्टडी सर्टिफिकेट आरी पड़छि तो सेम लोकर ସେଇଥିପାଇଁ ଡାଉଟ ହଉଛି ଆଉ ଗୋଟେ ଯଦି ସିଏ ସର୍କଲ ଜେଲ
ସେକେଣ୍ଡଟାରେ ଫାର୍ଷ୍ଟଟାରେ ରହିଲା 22/12/15 ଠୁ 23/6/14/4/21 ତାପରେ ଆଉ କିଛି ନାହିଁ 21 ତାପରେ ଏଇଟାରେ ଅଧିକା ଦେଇଛି 21 ଠୁ 23 ସେକେଣ୍ଡଟାରେ ଏଟା 21 ଯାଏଁ ଅଛି
କୋଉଟା
ଯୋଉ ଫାର୍ଷ୍ଟଟା ଯୋଉ 22 ଯୋଉଟା କୋଦଳାର ଯୋଉଟା 5 ବର୍ଷ 6 ମାସ ଦେଖଉଛନ୍ତି କଷ୍ଟଡି ଅଣ୍ଡର ଟ୍ରାଏଲ ହେଲା 22/12/2015 ଠୁ 14/4/21
बड़ा भूल देखी ये देखो एक्चुअल पीरियड 7 नंबर कॉलम को आसंतु जो सेकंड रिपोर्ट एक्चुअल कस्टडी पीरियड आफ्टर कन्विक्शन देखी 2 मास 8 दिन किंतु सेटारे देखौची actual period होची after conviction 3 वर्ष केते देखु କୋଉଠି ଅଛି ବର୍ତ୍ତମାନ କୋଉ ଜେଲରେ ଅଛି
ଲାଟେଷ୍ଟ ରିପୋର୍ଟ ବ୍ରହ୍ମପୁର
ହଁ ଖଲିକୋଟର ଇଏ ଦବା ଏଇଟା କୋଉଠି ଆସିଲା ଏ କୋଦଳାରେ କୋଉଠି ଆସିଲା
ବାଇଜେଣ୍ଟେଡ ସେ କୋଦଳା
Does it relate to this man?
ଲେଖା ହେଇଛି ବିମଳ କୁମାର ଲେଖା ହେଇଛି ବାପା ନାଁ ଲେଖା ହେଇଛି
ଏ ତ ଖଲିକୋଟରେ ଅଛି କୋଦଳା କୁଆଡେ ଗଲା ବ୍ରହ୍ମପୁର କେବେ ଗଲା
ସେ ମଝିରେ ମଝିରେ ଶିଫ୍ଟ ହୁଅନ୍ତି police।
and the order must be there na jail ରେ ଯେତେବେଳେ congestion ହେଇଯାଏ ସେତେବେଳେ bifurcate କରାହୁଏ so order must be there ସେ period order ଥାଏ
ବ୍ରହ୍ମପୁର ଗଲେ 23/6/21 that କୋଦଳା ରିଭର ଟ୍ରାନ୍ସଫର ଟୁ ସର୍କଲ ଜେଲ ବ୍ରହ୍ମପୁର that last part
ସେଟା କୋଦଳା କୁଆଡେ ଗଲା ଏ ତ ଖଲିକୋଟ
ନାଇଁ କୋଦଳା ଯୋଉ ଦେଲେ ଏସକେ ଏ ଯୋଉ ଜେଲ ସୁପରିଟେଣ୍ଡେଣ୍ଟ କୋଦଳା
ସେ କାହିଁକି ଦବ it is not within his duty ଏ ତ ଘଟଣା ହେଲା ଖଲିକୋଟ ଟ୍ରାଏଲ ହେଲା ଖଲିକୋଟ ସବ ଜେଲ ହେଲା ଖଲିକୋଟ କୋଦଳା କେମିତି ଦେଲା
ସେ ସେଠି ଯାଇଥିବ କାରଣ ଏବେ ବି ଆଉ ଗୋଟେ କେସରେ ଗଲା ଏଥରକ ସେମାନେ ଖଲିକୋଟର ସେମାନେ ଆସିକାରେ ତାଙ୍କର ରହିଛନ୍ତି ବୋଲି
ତାମାନେ other matters will be there
ଅନ୍ୟ କେସ୍
Mr. Remand is not a student of RCM college. He was a student of RCM college, Kolkata, Delhi, and Lancaster.
ବର୍ତ୍ତମାନ ଆପଣଙ୍କ ରିପୋର୍ଟ କଣ ଆସିଲା ଠିକ ଠାକ ଅଛି are the learned counsel for the petitioner and counsel for the state the learned counsel for the state has produced the report from IAC Kalikot police station to show that during the interim bail period no criminal case has been reported against the petitioner. Similarly, the petitioner has got no criminal antecedent. The petitioner was earlier granted bail by this court by order dated 27/11/2024 for a period of 3 months interim bail, and after availing the same, he has surrendered before the Lenin trial court, and the Lenin counsel for the petitioner has produced the copy of the surrender certificate. Stop. Which are taken on that, which is taken on that. Considering the submission made by the counsel for the respective parties, period of detention of the petitioner in judicial custody, since the petitioner has not utilized his liberty while on interim bail, another 3 months later. Yes, next. Please.
Item 35.
Please, here bail is being moved for the appellant number 1, who is in custody. He is the husband, been convicted on sections 498, 302, 34 and 454. Sorry. Conviction is only under 320. 498, 304 and 4B. The last order, my lords, may see updated 1512.
So if it has gone to the Honorable Supreme Court,
Miles. After this court rejected prayer for bail, the petitioner had approached the apex court, my lords.
And there also it was rejected.
Apex court observed that I could renew my prayer for bail if the hearing was not taken up within
6 to 8 months. And that order of the apex court was communicated by the registry also, my lords. It was received on 30th of November 2024.
No, technically that can be taken out because 6 to 8 months time ଦେଇଥିଲେ ଶୁଣାଣି ଏବଂ paper book ବି ହେଇଗଲାଣି
paper book ହେଇଯାଇଛି.
So
and this is a case of
get ready because
a case of no evidence.
No, it's rejected and confirmed by the Supreme Court otherwise.
No,
Get ready for hearing.
Supreme Court says, my lords, that I could renew
No,
it.
that's not fine. Get ready for hearing after ensuing Christmas holidays. Next.
Let the bail application remain.
Yes, yes. Bail application हम किस talks करेंगे? Yes. Next.
Item 36.
Made measures. This is the husband of lordships. This is the sufficient evidence has been convicted. Last of the lordships call for the conduct certificate, the authority certificate of the applicant lordships. ଆସିଲା କି? Imperial coup order ଯାଇଥିଲେ ଆପଣ? Lordships on 22/12/2022 lordships. अच्छा, 12 weeks ପାଇଁ ଯାଇଥିଲେ. Yes, lordship. Thereafter, for on by the order dated 27/4/2022 lordships. ତାପରେ ଆଉ ଯାଇଥିଲେ? ତାପରେ ମଦର ନାଇଁ 22/12/2022 ପରେ ଆଉ ଯାଇଥିଲେ କି ଇଣ୍ଟରିମ୍ ବେଲ୍? 22/12 ଆଉ ଥରେ ଯାଇଛି। ସେଇଆ ତ କୁହା ହଉଛି ଆପଣ କିଛି।
For a period of 1 month as per order dated 27/12/22 and for a period of 12 weeks as per order dated 22/12/22.
22/12 ଟା ଲାଷ୍ଟ ଅର୍ଡର ଥିଲା।
ଆଉ
Surrender is fine, behavior is good. 2 or 3 questions. Total period of 8 ବର୍ଷ ମାସେ 5 ଦିନ ଅଛି। Interim bail period, no cases instituted. Are the land council for the petitioner, land council for the state? The land council for the state has produced the custody certificate, which shows that the petitioner is in judicial custody for more than 8 years. He has also produced the certificate from jail superintendent that the conduct of the petitioner inside the jail is good. And he has also produced a report from the IIC Sadar Police Station, to show that during the interim bail period, there is no criminal antecedent against the petitioner, and during the interim bail period also, no cases has been registered. The reports are taken on record. Considering the submission made by the land council for the respective parties, period of detention of the petitioner in judicial custody, and since the petitioner has not flouted the terms and condition of the interim bail order, we are inclined to release the petitioner on interim bail for a period of 3 months. Yes, next.
Item 37.
Regular bail orders. First surrender and then secure. Next item number 37.
Last one notice जायला.
Huh?
Last one is the notice जायला. Notice.
Business petition at flag E କଣ ଗୋଟେ ଲେଖା ହେଇଛି? ହଁ ନୂତନ ଓକିଲ ଦେବ ବିଶ୍ୱଜିତ ନାୟକ ଗଲେ ଆପଣ ଫାଇଲ କରିଦେଇଛନ୍ତି ଓକାଲତ ନା?
ଆଜ୍ଞା ଫାଇଲ ହେଇଛି।
ଆଚ୍ଛା ତାପରେ ଲାଷ୍ଟ ଅର୍ଡରରେ କଣ କୁହାଯାଇଥିଲା 8/12/2025 to obtain instruction regarding service of notice to informer from the corporate certificate and jail conduct. Yes. Yeah. এটা লিখি দিଅନ୍ତୁ period the prisoner's petition at flag E which was received from special jail Raurkela regarding engagement of Mr. Vishwajit Naik in place of the previous counsel. Mr. Naik has already filed Wakalatnama which is accepted. Yeah. এটা কোন ডে? ସେ କଣ କହିଲା କି ଅପୋଜ କରିବ ବୋଲି?
ସେଇଟା ସେ ରିପୋର୍ଟଟା ସେ
କଣ ସେଇଟା ଅଫେନ୍ସ କଣ କି? ଓ ପୋକ୍ସୋ ଅଛି। ଓକିଲ ଦ୍ୱାରା
ସିମ୍ପଲି ନୋଟିସଟା ସର୍ଭ କରିକି
ଆମେ ଗୋଟେ ଅର୍ଡରଟା କରୁଛୁ ପୁରା ସେ ଯୋଉ ଯଦି ତାର ପଇସା ପତ୍ର ନଥିବ ସେ ଯଦି ଚାହିଁବ ଏଠି ଲିଗାଲ ଏଡୁ ତା ପାଇଁ କାଉନସିଲ ଏନଗେଜ କରିବ ଖାଲି ଓକାଲତ ନବାଟା ଆପଣ ଆଣିବେ ବୋଲି ସେ ଅର୍ଡର ପାସ୍ ହେଇନି କାହା
ଏଇଟା କମନ ଅର୍ଡର ଆମେ ଚିଠି ଲେଖୁଛୁ ସେଇ ଲେଟର ଯଦି
ଏଇଟା ଲେଖା ହେଇଛି It is financially unsound to engage any counsel. The counsel from High Court Legal Services Authority can be engaged for such purpose. And if he agrees to that, the Wakalatnama shall be collected. How can they
I've also sent the letter on that respect also.
ଆଦେ ତ ଲେଖା ହେଇନି ମୁଁ ତାଙ୍କୁ ପଚାରିଲି ସେ ମନା କଲା ଟୋଟାଲି ମୁଁ ଏନଗେଜ କରିବିନି ସେଇଟା ଲେଖା ହେଇଥାନ୍ତା ଆମେ ଜାଣିଲୁ ସେମିତି ତ କିଛି ଲେଖା ହେଇନି if your officers are not complying the order what is the purpose for them sending ତାଙ୍କୁ ନେଇକିନି ଦେଇଦେଲେ କି ଗରିବ ଲୋକଟା ହେଇଥିବ ସେ ମୁଁ ୟା ହାଇକୋର୍ଟକୁ ଯିବି ପଇସା ପତ୍ର ଖର୍ଚ୍ଚ ହବ ହଁ କଣ ଦରକାର ସେ ତାର ଚୁପଚାପ ହେଇ ରହିଲା ଅର୍ଡର ପର୍ପୋସ ହଉଛି ସେୟା ଯଦି ତା ପାଖରେ ପଇସା ନାହିଁ ତାହେଲେ ଏଠୁ ଏନଗେଜ କରାଯିବ ଆପଣ ଯୋଉ ନୋଟିସ ଦେଇଛନ୍ତି ତା ଦେହରେ ଲେଖିଛନ୍ତି କଣ ଆପଣ ଓଡିଶା ହାଇକୋର୍ଟରେ ହାଜର ହେବେ ନଚେତ ଓକିଲ ଦ୍ୱାରା ମୁଦାଲାଙ୍କ ବିରୁଦ୍ଧରେ ଲିଖିତ ଅଭିଯୋଗ ବା ଯୁକ୍ତି ଆପୋଷଣ କରିବେ କୋଉଠି ଲେଖା ହେଇଛି ଯେ ଆପଣଙ୍କ ପାଖରେ ଯଦି ଆର୍ଥିକ ସମ୍ବଳ ନାହିଁ ତାହେଲେ ଆପଣଙ୍କୁ ଆଇନ ସହାୟତା ଯୋଗାଇ ଦିଆଯିବ ଏସବୁ କିଛି ତ ଲେଖା ହେଇନି
ବିନା ମୂଲ୍ୟରେ ଆପଣ କହିପାରିବେ
ଏଟା ଫର୍ମାଟରେ ଏଟା ଆଡ କରିବା କଥା ଆଚ୍ଛା ସିଏ ଗୋଟେ ଏଲଟିଆଇ ବାଲା ବୁଝିକିନା ଆଣନ୍ତୁ ସ୍ପେସିଫିକ The London Council for the State has served the produced the notice which has been served on the informant along with the custody certificate custody certificate custody certificate and jail conduct however if submits that since there was a specific order passed on 17/11/25 that in case the informant is financially unsound to engage any counsel, it is to be intimated to him that a counsel from the High Court Legal Services Authority can be engaged for such purpose, and if he agrees to the same, Wakalatnama shall be collected. The Land Council submits that there is nothing in the documents of the IIC Raiboga police station that such an offer was given to the informant. Therefore, he requires some more time to obtain proper instruction from the informant through IAC Raibur police station. List this matter in the second week. These are taken on record. Second week of January 2026. Yes.
Item 38.
No, I'm 15,000. Postpone certificate and jail conduct. It was also.
Agu reject ହେଇଥିଲା
On 8th November 26.
reject ହେଇଥିଲା nothing on one section. 9 years, 10 months, 19 days. Conduct verification. Bail भी जाइए आपको interim bail भी long bail भी जाइए are the land council for the petitioner land council for the state. The land council for the state has produced the report from the deputy superintendent of police in charge.
Objection to the claim. Objection to bail. By the state respondent, state respondent.
Binjarpur police station, Jajpur, that there is no criminal antecedent against the petitioner. Stop. The custody certificate has been produced from the jail superintendent to show that the petitioner is in custody for more than 9 years and 10 months. And the jail conduct was very good. The documents produced by the land council for the state are taken on record. Land council for the state, however, suggests that the bail application of the petitioner was rejected on merit as per the order dated 8/11/2023. Considering the submission made by the land council for the respective part, in view of the available material on record, while not inclining to release the petitioner on bail on merit but taking into account the period of detention, official custody, and absence of any chance of early hearings, we are inclined to release him on interim bail for a period of 3 months. Yes, next.
Item 39.
This is the last order. Yeah, appellate number 1 in custody over 9 years, excluding the period of interim bail and furlough. And the appellant number 2 in custody for about 6 years, 5 years and 10 months. The custody certificate I have got, I have filed the custody certificate
from I think purchase at purchase. He was allowed for 3 months on 25/8 and 25.
Yes, yes. And surrendered in time.
When did he surrender?
Surrender, my lord, sir. I have given the custody certificate.
चार बार में पुराई
क्वेश्चन है कि 20/8/2024 रे आपनकर ऑर्डर पास हला
आज्ञा आज्ञा
आपण केबे सरेंडर
4/12/24 में सरेंडर कर
4 December
आज्ञा लेकिन this matter in the month of February 2026. Yes, next.
Item 40.
The contract certificate or 6. Connected only 15th 11 to have rejected in 23 September 20. So what is the period of hospital certificate? 10 years. Asking. Custody certificate, criminal antecedent, jail conduct in Magaitala, order dated 10/12/25. Certificate হচ্ছে 10 বছর 7 মাসের তারপরে জেল কন্ডাক্ট single murder. Yes, my
The time declaration of the
This is the time declaration.
doctor. The government has mentioned.
Once it was elected.
Judicial is a dying reason.
Remove the nuclear tolerance and clearly stated that the class by the settler has intention to get.
Or the land council for the petitioner land council for the state. As per the previous order, the land council for the state has produced the custody certificate to show that the petitioner is in judicial custody for more than 10 years and 7 months. And he has also produced the jail conduct certificate from the senior superintendent, which shows his conduct to be satisfactory. He has also produced the report from the IAC Bhadrak Rural Police Station that there is no other criminal antecedent against the petition. And counsel for the state submits that the bail application of the petitioner was rejected on merit by the order dated 14/9/2023. Considering the submission made by the land council for the respective party, view of the available material on record while not inclining to release the petitioner on bail on merit but taking into account his period of detention in judicial custody and absence of any chance of early hearing, we are inclined to release him on interim. Yes, next.
Item 41.
Last second mailer directed to obtain the conduct of the petitioner file he was on an interim bail mailer. Last state mailer directed to obtain instruction the conduct of the petitioner file he was on
interim bail
mailer. That I have obtained mailer. The petitioner, the IAC Ganja Aska, he filed a report that the present petitioner is involved in 8 cases. In response to that, petitioner filed an comprehensive affidavit that he has authored 12 cases of different police stations. I have communicated that comprehensive affidavit to the IAC. IAC made a request to verify that it's being a time matter.
24/11 ଆମେ ଫାଇଲ କଲୁ ଭେରିଫିକେସନ କରିବାକୁ ବର୍ଷେ ଲାଗିବ ଶୀଘ୍ର କରିଦେବୁ ନହେଲେ
Father's funeral ceremony. For a period of 2 years, surveillance and parties are watching this. Further time mentioned. The Learned Council for the state has produced the report from IAC Gangapur Police Station dated 21/12/2025 to show that during the interim bail period, the appellant was residing in house and he was kept under police surveillance as his life was full of threat and the opposite parties were watching his movement to take revenge. Another letter was produced by the IAC Aska Police Station dated 22/12/2025, praying for time to obtain instruction regarding the involvement of the petitioner in other cases. In view of such, these letters are taken on record. Secondly, problem. Yes.
Item 42.
Yes, Mr. Maharana.
Report was called for regarding conduct.
Upon PP ଯାଇଥିଲେ individual
2024 ଅଛି
24 ରେ ଯାଇଥିଲା କେତେ ମାସ ପାଇଁ 3 ମାସ ପାଇଁ
3 months
ଠିକ ସମୟରେ ସରେଣ୍ଡର କଲେ
ଅଛି and given the surrender certificate
ସରେଣ୍ଡର ସାର୍ଟିଫିକେଟ ଦେଇଛନ୍ତି କଣ ଆସିଲା conduct certificate
conduct certificate yesterday night I also tried to contact the IAC Potangi could not contacted today morning contact is in CORAM उत्सव जो होची को सेठी
ଲେଖନ୍ତୁ the Learned Council for the state system for the time to produce the conduct certificate while of the petitioner while on interim bail put up this matter second week of January 26. Yes, next.
Item 43.
My lord. Under says IU number C124/2025, appellant number 2. Offense committed 302-449.
Conduct certificate ആണ്
Last order.
He was doing labor work, spent those days in a right visibility. His conduct the bail period was satisfactory. କେତେ ବର୍ଷ ରହିଲା ପରେ ଆପଣଙ୍କୁ interim bail ଦିଆଯାଇଥିଲା
7 years. ଏବେ 8 years. Minor 1 and 3 derivation Sudiraj revision to the draft.
469 eyewitness and 15 doctor.
Minor revision the bail P9/2020.
This appellant number is who is he?
Ramratha Das.
Who is he? How is he related to the?
Yes, related.
Is it's a case of dowry death or what?
No,
No, my lord.
Family ଭିତରେ due to civil dispute to entering into the house on said month.
449.
Same dispute, same.
So what he says that the other two appellants, they were first granted interim bail, and then they, since they did not flout the terms and conditions, I think they were granted bail till the final disposal of the appeal. That is order dated 3/9/25. Appellant number 1, Billy Das, and appellant number 3, Sudhir Das. So is there any difference between, because period of detention is same and
No, my lord. No. Serial number ଏକାଶୀ 2003 ଗୋଟିଏ
ସିଆର୍ଏଲ୍ ନୁହେଁ, ଆପଣ ବେଲ୍ ଆପ୍ଲିକେସନ ଟା ଅଲଗା ଅଲଗା କରି ଫାଇଲ କରୁଛନ୍ତି ନା? ବେଲ୍
No, my lord. Billy Das, Sudhir Das, 103. D Das sir, Avinash sir. और ଆମର ଥିଲା ସେ D ଆପଣ SP sir and RK Bhatt.
Ramaratha Das, he assaulted by Ramaratha stabbed.
Yes, he's the
हाँ सही है। So Ramaratha is the main
assailant.
No, my.
Oh no, my. It's a PW4.
PW4.
Yes.
PW4.
At about 8 p.m., I was about.
PW.
At about 8 p.m., I was about to serve dinner to my husband. All the three accused persons enter into my house and suddenly accused Sudhira and Dilip caught hold both the arms of my husband, and the accused Ramaratha stabbed my husband at his chest.
And that to 5 times. So, also ଆପଣଙ୍କ ନାଁର ଆଲିଗେସନ ଆଉ ତା ଭିତରେ ପାର୍ଥକ୍ୟ ରହିଛି। ସେମାନେ ହାତ ଧରି ପକେଇଥିଲେ, ଆପଣ you have stabbed in 4 to 5 times. How do you say that ସେମାନେ ଯାଇଥିଲେ ବୋଲି ଆପଣ କହିବେ?
And corresponding injury are also there, 6 number of
6 injury. So,
No, my lord. PW3, 8, 10 and PW12 and 13 did not support the prosecution.
ଯୋଉମାନେ ସପୋର୍ଟ କରି ନାହାନ୍ତି ତାଙ୍କୁ ଛାଡି ଦିଅନ୍ତୁ। ଯୋଉମାନେ ସପୋର୍ଟ କରିଛନ୍ତି ସିଏ କରିଛନ୍ତି, ସିଏ ଆପଣଙ୍କ ରୋଲ ଆଉ ଯୋଉମାନଙ୍କୁ ଆମେ ବେଲ୍ ଦେଇଛୁ ତାଙ୍କ ରୋଲ ଭିତରେ ଡିଫରେନ୍ସ ସିଏ କହୁଛନ୍ତି। You are the person who stabbed 5 times on the chest of the deceased,
vital part of the body.
Vital part of the body, ଆଉ ସେମାନେ ଖାଲି ହାତ ଧରି ପକେଇଥିଲେ। ତେଣୁ that is the why how do you claim parity with them?
In presence of inmates of the house, the family members, wife.
ଆପଣ ଯାଇଥିଲେ ବେଲ୍ ପୁରା କେବେ ଯାଇଥିଲେ? ଯୋଉ 3 ମାସ
9/5/2025 surrender କଲେ 19/8/2020।
ଯାଇକିନି ତ ଏବେ ଆଇଛନ୍ତି ଆଉ ଟିକେ ରୁହନ୍ତୁ election. The Lion Council for the state has produced the report of the IIC Hindi police station.
ମାନେ ଆଉ କି
ଯିବ ଯେ ଆଉ ଟିକେ ପରେ ଯିବ। That no, during the interim bail period, the conduct was satisfactory. The report is taken on record. This interim application be placed in the month of February 2026. So it's like for consideration. आगे लिखी दी भाई number 1, this is an application for bail of appellant number 2. No, February 26. Yes, next.
Item 44.
As per the State Council was requested to submit the possible certificate.
Yes, I have up.
Appellant number 2 and 3. Lion Council for the state has produced the reports once. Received to show that nothing adverse was found against each one. However, state submit that he may be given some more time to obtain the custody certificate to also the jail conduct action.
तीन जणकर अच्छी था ये सब ट्रिपल मर्डर the accused person are only 4 years and
छुट्टी कर देते हैं February. Yes, next.
Lords, they were on bail from 7/11/98 till the
Ashwas, February 26. Next.
Item 45.
Yes.
On respect on the section 302, that is the arms act manner. Prosecution case is that he has come in the midnight and saw the deceased brother. The prosecution case is that both were in the illicit relationship. That's they came and forcibly wanted to take the deceased. When she denied, if there is no eyewitness, madam, case is based on circumstantial evidence, madam. And
What is the options, madam?
302, madam. And that is arms act.
But they one year.
Lordship, on the last occasion called for the CA report. I may be permitted to place the CA report.
Not week today. What report, madam? On a report.
Aguru reject ହେଇଛି
No, madam. This is for the first time.
First time,
madam. Prosecution relied the
how many years he is in custody?
6 years completed, madam. 23/11/2019 arrest हुए.
Page 13 of the paper book. He got arrested on 27/11/2019. He was also out in custody.
Till 2023.
Yes.
So that is 4 years.
These two cases, one is this particular case or what?
Yes, sir. The 772 relate to the present case, and the other case of 2019 relates to the deceased only.
Deceased?
That has been explained in the Kindly see page 67 for a minute. Yes. Kindly see page 67 of the paper.
67.
67.
Paper
The internal page 56 of the judgment. These are the circumstances which have been culminated by the learned trial. May I please? The
extramarital
relationship and which was denied by the deceased, for which she was assaulted. Once on the earlier occasion, accused had abducted the deceased on gunpoint to go with him. Yes, sir, first case type. The deceased managed to escape from the clutches of the accused 4 to 5 months prior to the occurrence and was staying with her family members at Swanso. While was staying with her family members, she has expressed her unwillingness to go with the accused. Even she had disclosed her family member that the accused was threatening her to kill her and family members if she will not go with him. Staying of the accused in the rented house at the Swanso. These are the following circumstances.
My submission before Lordship is that the actual case is not there, manner. The actual culprit might be someone else, manner. The prosecution has brought that their relation was not in the inimical state. But in the midnight, I am admitting for the sake of argument that both were in the illicit relationship manner. But that doesn't mean that he has come to that house in the midnight and killed that girl and straight away. In the midnight meeting.
That case was registered.
Yes, ma'am.
That you are on a gunpoint, you are trying to kidnap. And also
kidnapped. Yes, ma'am. Kidnapped, not strike. Kidnapped.
Very girl,
yes, ma'am.
Whom you subsequently that murdered. That was against that girl also the allegation.
She is Major Woman Mallard. She is the wife of the informant PW2 Mallard.
What happened in that case?
Is the statement of the IO that it has been charge sheeted against the.
No, charge sheeted obviously victim examine he par nothiyo to death higala na apno 302 ta kar de hela pare so she might have been examined
from the case itself, my lord. Case is made out that the real culprit might be someone else, my lord. The
real apno na charge sheet heichi na
sei to
somebody else mane apno trial re seta praman karebe, that's a different matter.
No, why
fact remains that lady for kidnapping or whatever outraging
in the month of April she was kidnapped.
A case was registered.
In the month of November she was killed by the in the month of April she was kidnapped by the present appellant,
for refusal to continue with the extramarital relationship.
She has not killed
There
at all,
in the
ma'am.
month of November, she was killed.
There
She
is
will
no-
kindly see PW4 for a moment.
There is no eyewitness to that occurrence, my lord. In the midnight
See
coming and
PW4 for a moment.
from the outside, my lord, in the ମଧ୍ୟରାତ୍ରି ମାନେ ମଧ୍ୟରାତ୍ରିରେ ସେ ବାହାରିଲା ଆଉ ପୁଅଟାକୁ ଭେଟିଲା. It's showing that relation was intact, my lord. Relationship, if there was any fairness to the life, a lady will not, a mother, he is not a minor girl, he is a
That is
mother.
what, that is how, when she refused to
ଆସିକି ତାକୁ
continue the
ଭେଟିଲା,
relationship,
relation was
she was
intact,
killed.
it's showing, my lord.
PW4 is the
କିନ୍ତୁ
person
PW
who saw the accused fleeing away with the.
Next.
My lord, one more thing, my lord. In this case, PW9 statement, your lordship may kindly have a glance.
February.
Item 46.
46 next.
Lord, in this case, the petitioner is a husband, man. The applicant is a husband, and who has convicted under section 302 and 498 abuse manner. And the case is based upon the circumstantial evidence, and the deceased and the applicant was love affair to each other, and he has a marriage to thereafter has a marriage solemnized between them. Then the
Page 44, where the circumstances of the case has been witnessed to, I think.
basically 106 evidence due to non-explanation of the death.
ଆପଣ ଘର ଭିତରେ ମର୍ଡର ହେଇଥିଲା
ସେଇ ଜାଣିବେ answer
you are the husband staying with the
Within
guilty.
7 months of marriage.
Oh,
7 months.
Strangulation rate
Yes.
na.
Cause of death is asphyxia due to strangulation. Cause of death is asphyxia due to strangulation.
That is we have seen.
Yes, sir.
Circumstances right.
Yes.
So କେତେ ବର୍ଷ ରହିଲେଣି?
7 years 3 months now. The other has been prosecution stated that due to love affairs between the doctor and the president applicant matter.
ସେ ସବୁ ଠିକ ଅଛି
Only that is the ground that is non-expansion of the
ତ ଘରେ ଥିଲେ ଆଉ ତ ଘରେ ସ୍ତ୍ରୀ ସହିତ ଥିଲେ ଗଳା ଚିପା ହେଇକି ମରା ହେଇଛି ଆପଣଙ୍କ ପ୍ରେଜେନ୍ସ
continuous case of torture, dowry demand and ill treatment.
Dowry demand is high. When PW16 the IU was clearly stated that no dowry demand is.
PW6 and 7 who are the relatives of the deceased, they say they are
father and
continuous
mother.
torture.
Because my kehi ଯାଉନଥିଲେ. Kind of they do not fulfill the final.
One of the circumstances on the fatal night, the deceased along with the accused, that means you were sleeping in the same room,
Yes, sir.
which was bolted from inside, and the death was asphyxia caused by strangulation. It is homicidal as per the PM report, and the ligature was a sari that which was used for strangulation, that was also seized, and you have not offered any explanation.
But non-expansion to accused person will be famous. But the DDoL 1 stated that in at 4 AM.
DW.
DDoL 1.
DW1.
DDoL 1.
Who is he?
The defense should be.
कौन है वो?
This was just I have accused person was went to the taking a she was a driver mother.
Plea of LAV.
Was left at 4 AM.
ଆପଣ ଦେଖିଛନ୍ତି କୋଉଠି ଇନକ୍ୱେଷ୍ଟ ହେଇଛି? ମୁସ୍ତାଫା ପୂଜାରିଣୀଙ୍କର ମୃତ ଶରୀର ଶାଶୁ ଘର ତ୍ରିଲୋଚନପୁରରେ ତାଙ୍କ ଶୋଇବା ଘର ଫଟୋ ଉପରେ ଶୋଇବାର ପାଇଗଲା। ଆଉ ବାହାରକୁ ଯାଇକିନି କଣ ଘଟଣା ହେଇଥିଲା?
ନା ସେତେବେଳେ ନଥିଲେ ହଜବାଣ୍ଡ ନଥିଲେ ବୋଲି ଲେଖିଥିଲି।
ଆସୁଛଟା ଫେବୃଆରୀ ନେକ୍ସଟ
Item 47.
February. Next, 47.
Kindly see order dated 7/4/25. It was earlier rejected.
7/4/25.
Yes.
So on behalf of Siddharth Kutumbas, I pray for
Adjournment of the February 2026. Next.
Item 48.
After this interim bail period has surrendered within the time matter, it also directed a report to be called for. That report has not come.
Called for a report from the IAC Banki regarding the conduct of the
2nd January 2026. Second week.
May I please?
Let the report be produced.
May I appear for the appellant number 5.
Yes, next item 49.
Item 49.
Page 103.
Let it come after
after second week. Yes, next.
After waiting.
Item 50.
50.
Item 50, my lord, item number 1, my lord.
Item 50, January second week. Next.
49, my lord, by sub-item.
Yes, 20.
Sub-item, my lord.
Item number 1, my lord.
All good.
Item number 1, my lord, unnecessary for